The clerk will now proceed to read the orders of the day.
European Union Withdrawal Arrangements Bill, second reading.
Jim Allister.
Yeah, Thank you, Madam Deputy Speaker. I beg to move that the bill be now read a second time. I wish to begin by thanking my co-sponsors for their help and support in respect of this bill. Sir Iain Duncan Smith, Graham Stringer, Gavin Robinson, Nigel Farage, Robin Swan, Sammy Wilson, Richard Tice, Carol Lockhart, Alec Easton, Jim Shannon, Mr Gregory Campbell, all honourable and right honourable members of this House. I also wish to thank my own staff for the help and assistance during recent weeks in respect of all these matters, in particular Dr Dan Boucher, who has worked tireless hours on this matter. And I want to record my appreciation for the help and guidance of international lawyer Mr Barney Reynolds for his help in respect of many of the technical issues. Madam Deputy Speaker, since I came to this House in July, I have lost count of the number of times I've heard from the government benches affirmations about fixing the foundations. Well, there's one foundation that most assuredly needs fixed, and that's the foundation which flows from the inequitable post-Brexit arrangements as they affect my part of the United Kingdom, Northern Ireland. Because the foundations of this United Kingdom have been disturbed and dislodged by these arrangements. So the primary purpose of this bill is, yes, to fix those foundations, to restore equilibrium to Northern Ireland's place within the United Kingdom and to our relationship as a nation with the EU. In fixing the foundations, we need to reflect on the most basic tenet of democracy, namely that a people should be governed by laws made by those they elect to make those laws. That is so fundamental that we all, presumably, almost take it for granted. Yet, tragically, and with great constitutional detriment, that is no longer the position in respect of Northern Ireland. There are 300 areas of law where the right to make those laws is not exercised in this House, is not exercised in the devolved Assembly, but has been surrendered to the European Parliament. That is such a momentous thing that it should cause anyone who values the fundamentals of democracy, who clings to that principle, that you're entitled to elect those who govern you and those who make your laws, that we should be ashamed that that situation has evolved. Madam Deputy Speaker, that is not just a democratic deficit. It's undemocratic plundering of the Northern Ireland Statute Book by the EU. And these are not incidental matters. These are not trifling issues. No, they are the laws that deal with customs, the laws that deal with general trade, that deal with goods, with motor vehicles, with cosmetics, with toys, with electrical equipment, with textiles, with medical devices, with pesticides, with waste, with food hygiene, with food ingredients, with marketing. 13 different areas of law in terms of food alone. The laws that deal with animals, that deal with disease, the breeding of animals, the welfare of animals, the identification of animals. 34 different diktats of the EU govern all of that. Yes, I'll give way.
I thank the gentleman for giving way, and I appreciate his passion. He also needs to be honest to this chamber that the laws that he's talking about include human rights laws and the basic equal treatment of everybody in Northern Ireland. So his legislation would rip up the very foundations of democracy, which is that everybody is equal. He needs to be honest with this chamber, does he not, that when he's looking at those 300 laws, it includes equal human rights.
I will be absolutely honest with this chamber, and to be absolutely honest with this chamber, I have to say that the honourable member is not addressing the issue as it emerges, because I will deal with the impact of Article 2 of the protocol. I want nothing more for my constituents than the same rights as the honourable lady has for her constituents, be they human rights, be the rights to make the laws of our land, or any other rights. I ask for no privilege, but I certainly do not accept any detriment, and that is the point here.
Way, because he and I then share a common concern, because my constituents in Walthamstow do benefit from protection of their human rights, because we are still members of the European Court of Human Rights, which is indeed what the Good Friday Agreement was based on, that equal access to those human rights. His legislation and what it does to Article 2 of the Windsor Framework breaches those principles. So actually, if it went through, there would be less of a connection between the constituents here in England and the constituents in Northern Ireland, would there not?
And utterly disagree. As part of the United Kingdom, we are all subject to the Human Rights Act. The Human Rights Act is what fundamentally gives her constituents the rights that they have in that sphere. And there is nothing that she would lose by losing the control of the foreign court of the European Court of Justice. Let me continue with the point, if I might. I am listing the some of the just examples of the 300 areas of law that have been purloined by the EU in their sovereignty grab over Northern Ireland. I mentioned the 34 different diktats on animals. We've even reached the point in Northern Ireland where, under these arrangements, our cattle cannot any longer bear a UK ear tag. They now have to have a specified European Union ear tag. And that is but an illustration of how absurd and utterly wrong and offensive it is that the right to make the laws in our own country has been surrendered to a foreign power. All those 300 areas are set forth in Annex 2 of the Protocol, or it's now more kindly called the Windsor Framework. Look at Annex 2. Look at the hundreds of laws, 289 of them, which now have been removed from the ambit of the lawmaking of this House or the lawmaking of the Northern Ireland Assembly.
Would you give way on that point?
Yes?
It's just amazing to look at the volume of law, that 70 pages are contained, not the detail of the law, but simply the headings of the laws. That shows the extent to which the EU has its foot in the door in Northern Ireland.
Yeah. Absolutely. I printed them off a couple of months ago and I was staggered. Just the titles, how voluminous even they are. And it's not just 300 laws, it's 300 areas of law which have been surrendered in that regard. And my challenge to every member of this House who comes from a different part of the United Kingdom than Northern Ireland, those who represent GB constituency, my challenge to you today is, how would you feel? How would you feel if in 300 areas of law affecting your constituents, you had no input, you couldn't change, you couldn't move an amendment because those laws were made colonial-like in a foreign parliament by those elected not by your constituents, but by the constituents of 27 other countries? How, I ask this House, could any Democrat, any representative MP say that is right and correct? Yes, I give one.
I thank the honourable member, and I thank him for introducing this debate into the House. He's talking about the democratic deficit. Is it not right that the Northern Ireland Assembly will be debating consenting the procedures on the 10th of December, and are we not preempting that debate by holding this debate here now?
I'm grateful to the honourable member. I will be dealing with that. But he invites us to think that it is appropriate that those who are elected to the Northern Ireland Assembly should turn up on Tuesday of next week and vote to disenfranchise their own constituents. To say, you, our constituents in Northern Ireland, who sent us to the Northern Ireland Assembly, we are not worthy to make your laws. We must bow to the superiority of a foreign parliament, and we must surrender to that foreign parliament the right to make these laws in hundreds of areas of law. Now, the honourable member might think that is admirable. He might think that is the very epitome of democracy. I happen to think it's the very opposite of that. I'll give way.
Thank you. Surely the bill would create a democratic deficit that you've already referred to. The Windsor Framework has addressed with the Stormont break, which allows the Northern Ireland Assembly to review all laws applied.
Well, the member, I would respectfully suggest, should read a little deeper, and she will discover that the Stormont break is farcical. The previous member for North Antrim in this House aptly described it. He said, it's like someone sitting in the back seat of a car and saying to the driver, would you ever be so kind as to pull the brake? That's what the Stormont break is. It's a request to the British government to pause the imposition of an EU law. The British government doesn't have to do it. There's been one request to date and nothing has happened on it. So it really is a fiction and an insult to the democratic mandate of the people of Northern Ireland.
I'm most grateful to the honourable member for giving way. To continue the anecdote, it's been described to me that the Stormont break is rusty and not attached to anything.
Yeah. And when you pull it, if you could, nothing happens. So that's the value of it. So now, the most, Madam Deputy Speaker, the most limp excuse that I hear for this plundering of the Northern Ireland Statute Book by the EU is, oh, international law requires this. Sorry? What sort of international law says a state must self-harm by disenfranchising its own voters? There is no such international law. And I'll deal later on with the fundamental basics of international law and how they have been distorted in justification of these arrangements.
Honourable Gentleman, give way.
Yes, I'll give it.
First of all, can I commend the Honourable Gentleman for Northampton for bringing this forward. It's very important for us in Northern Ireland to, and for this whole great United Kingdom of Great Britain to look at this. Our constituents must not by stealth lose their place in the United Kingdom of Great Britain and Northern Ireland without consent. And this is what this is. Brexit was a vote for all of us to leave Europe, not for Northern Ireland to leave the UK. And the outstanding of this is detrimental to our economy and peace and stability. Does the Honourable Gentleman agree that today this bill must be supported by all in this House if it's justice for all in this great United Kingdom of Great Britain and Northern Ireland.
The honourable member touches upon a fundamental. In June 2016, we all had the opportunity to vote on Brexit. Some liked it, some didn't. But the fundamental was this. The question on the ballot paper was, do you want the United Kingdom to leave the EU? The question was not, would you like GB to leave and leave Northern Ireland behind? But that's what we've got. And that is the fundamental denial of Brexit to my constituents in Northern Ireland. And that is the source of the disparity and the undemocratic consequences which have flowed from that. I mentioned the 300 areas of law. I mentioned the fact they're all recited in Annex 2 of the protocol. It is no surprise, Madam Deputy Speaker, that the very first area of law covered in Annex 2 is customs. And the very first law put upon the people of Northern Ireland is the EU's Customs Code, EU 952 of 2013. And what does it do? Well, the EU's Customs Code operates on the basis that GB, those of you who got Brexit, is no longer a part of the EU. It is, in the words of the Customs Code, a third country, or in common parlance, a foreign country. Whereas Northern Ireland is treated as EU territory. And therefore, under the Customs Code, we have this absurd insult that goods coming from GB, a supposed part of the United Kingdom, have to be, I'll give way when I finish the point, that goods coming from Northern Ireland, to Northern Ireland from GB, must be subject to all the rigour of declarations, of checks, of reportings, of data recording. Why? Because GB is treated as a foreign country when it sends its goods in the main, and particularly its raw materials, to my part of the United Kingdom. That is the iniquitous effect of the Union partitioning, dividing Customs Code and Protocol. Some members seem to find that amusing. I'm telling you, if you believe at all, maybe you don't. If an honourable member believes at all in the United Kingdom, maybe some don't, then should they not be as offended as I am by the fact that they move goods from one part of the United Kingdom to another is subject to an international customs border under the control of foreign law? How could any amused MP or otherwise think that is right and equitable? Thank you.
Thank the honourable member for giving way, and perhaps he'd like to reflect on something that I support, which is a veterinary agreement between the EU to reduce the checks on goods between Great Britain and Northern Ireland, which would in fact have to honour our existing commitments under the Windsor Framework if it was to come into effect.
We wish to see the whole of the United Kingdom sucked back into the EU. I want to see my part of the United Kingdom enabled to follow the rest properly out of the United Kingdom. And all this, Madam Deputy Speaker, for an international border over which the trade flow is infinitesimal. In 2020, and of course we've had diversion of trade since, but in 2020, 0.003% of all the goods and trade into the EU passed from Northern Ireland to the Republic of Ireland. 0.003%. And yet for that, we are building, at the cost of tens of millions of pounds, border posts. The Honourable Member for East Antrim's constituency, at Larne, in Belfast, at Warren Point, spending tens of millions of pounds to build border posts for an infinitesimal amount of trade, when, as I'll come to, there is another way. And where... Yes, I'll give way.
I thank the Honourable Gentleman for giving way, and he is talking with great passion about an issue that's really important to him, and he has raised this many times in this House. But he will know that 2020 isn't a representative year because of the pandemic. He will accept that. And also, whilst it might be a small part of trade within the EU, it's probably very important to traders in Northern Ireland, including those in his constituency. They must value that trade with the wider EU. And I know many businesses in my constituency of Edinburgh South West are still struggling to come to terms with Brexit. Absolutely. And they envy the relationship that Northern Ireland has with the EU when it comes to trading. They absolutely envy it. He must recognise that.
Well, I will say this, and I will deal with it more fully. The trade that matters the most to Northern Ireland is the trade with our biggest partner. And our biggest partner is Great Britain. It's the source of the overwhelming majority of our raw materials that keep our manufacturing industry going. And yet, under this pernicious REC border, that trade is fettered. And all raw materials have to pass through the full ambit of a full international customs border. So, sorry, his constituents, if they envy the position of my constituents, really need, like he does, to reassess the situation. It is nothing to envy.
Another member, and I thank the member for bringing this bill. At Prime Minister's questions, I asked the Prime Minister about the general product safety regulations that will come into effect next Friday, this day week, which will actually see suppliers from members in all parts of this House, from England, Scotland and Wales, actually have to increase bureaucracy, increase costs, if they still want to supply Northern Ireland consumers and Northern Ireland producers. Does the member agree that it's absurd that we're putting additional costs on our own internal UK market to actually facilitate some of the requirements of the European Union?
I'm grateful and I absolutely do agree. And the consequence of that is something we are already seeing. That increasingly, and again this seems to be a matter of some humour for some on the opposite benches, what we're increasingly seeing is that GB suppliers simply stop supplying because they won't put themselves through the rigours of the customs code, documentary declarations and all that goes with it. And that is a very difficult issue for anyone who's trying to do business in Northern Ireland, to find that small suppliers, and they're in the main the small and medium-sized businesses who don't have the resources to employ the extra 10 staff that a big business might need to meet the requirements of the REC border. They don't have those resources, so they simply stop supplying Northern Ireland and they feed the diversion of trade which is continuing. There's a member over here.
There was a report that came out 2 days ago suggesting that the Northern Ireland's economy was going to be stronger than the rest of the UK's. Does that not have something to do with the Windsor Framework, which is allowing business to invest in Northern Ireland? And surely that is a good thing.
Well, the honourable member might be interested to know that the growth area of the Northern Ireland economy is the services sector. And the services sector is the one sector which isn't included by the protocol, which is outside all of that. So the one sector that's outside is the one sector that is increasing, and there's a clear message in that.
Very grateful to the honourable member, Madam Deputy Speaker, and I hadn't intended to intervene on him, but just on that point, Invest Northern Ireland, yes, the body which is charged with encouraging foreign direct investment into Northern Ireland and in growing our economy, is not able to point to one example of business investing in Northern Ireland as a direct result of the Windsor Framework.
Absolutely, and I will return to that. I'm going to make some progress. I will be as generous as I can with interventions because I know that members opposite want to talk this bill out, because they're not shamefaced enough, some of them, to vote against the principles of this bill. But there we go. The right honourable gentleman makes a very important point, and the reason that point has traction is found in EU Regulation 2017-625. What does that do? It's the regulation which determines, according to our courts, that Northern Ireland is for these purposes EU territory. We've had several legal cases in Northern Ireland. We had a case called Rooney, and the Rooney judgment establishes that EU official controls that must be in place for food, for feed-law, for animal health, for plant health, etc., have to be in place because our High Court has ruled that under that applicable EU law, for regulatory and customs purposes, the entry point to the EU is Northern Ireland ports. Now, could it be any more union dismantling than that? That the entry point under EU law to which we are subject is the ports of Northern Ireland. Mr. Justice Coaten said EU regulations must be interpreted according to EU law. That's the result of Section 4, Article 4.1 of the Withdrawal Agreement and Article 13.2 of the Protocol. And he goes on to say, of course, those have domestic effect in the United Kingdom because of Section 7A of the European Union Withdrawal Act of 2018. And he said this: it is at Northern Ireland ports that EU territory is entered under the withdrawal agreement. The UK, he said, is not to be treated as a unitary state for the purpose of OCL checks coming from Great GB to Northern Ireland. Could it be any more stark that Northern Ireland has been colonised by the EU? What is a colony? In a moment. What is a colony, Madam Deputy Speaker? It is a territory governed by someone else's laws from a foreign jurisdiction. When you have 300 areas of law, including customs, including the very definition of what is Northern Ireland's territory in trading terms, which are governed by foreign EU laws, then you have created the situation where Northern Ireland in that context is a veritable colony. There are many people in this House, and the benches opposite are populated by many who boast of their anti-colonialism. They constantly pride themselves in their anti-colonial heritage. And yet here we have a part of this United Kingdom colonised by EU law to the point where we're told that when you enter the ports of Northern Ireland, you enter EU territory. I give way.
Very grateful to the honourable member giving way. I believe that the European Union is our ally. 27 democracies, and I have to say I am concerned by some of the language I'm hearing. He talks of colonisation, he talks of surrender, and I would just gently ask whether that is the message that we want to send to our 27 allies and friends in the European Union.
Maybe the honourable member could help me. What would he call taking a territory and subjecting it to someone else's laws? What would he call it other than colonisation? Isn't that the very essence of what he and his colleagues wear as a badge of pride in their anti-colonialism? Isn't that what it is in name and in truth? Yes.
does he remember that these so-called allies, during Brexit negotiations, made it quite clear that the price of Brexit would be Northern Ireland, and Northern Ireland removed from the United Kingdom. So far from being allies, they actually declared themselves to want to be colonisers.
Yes, that was the boast of Mr. Barney and his staff, that the price of Brexit would be Northern Ireland. Would be Northern Ireland. And so it is proved to be. Now that may be something of indifference, something indeed of pride for people, some people in this House, but it should be a badge of shame that we allowed a part of the United Kingdom to be so colonised by the EU and to have our rights to make our own laws surrendered. Yes, I'll give away again.
Very great giving way again. I just want to clarify for the record on the House whether it is his view that the 27 member states of the European Union are not our allies. We've had at least one member make that point. We've had another next to him. I think it's really important that that's on the record for this House. Does he believe the 27 member states of the European Union are allies of the United Kingdom or not? I certainly do.
The EU has behaved not as a friend to Northern Ireland. The EU has behaved as a sovereign grabber in respect of Northern Ireland. And that is where they caused the offence and continue to cause the offence. And if honourable members think it's a good thing to back that up, to endorse that, then they obviously don't think very much of the territory of Northern Ireland. Yes, I'll give way.
It's moving slightly into the ridiculous on this. Can I just bring back to the main point, which is the purpose of today's bill, which he has drafted, is simply to give a solution to what is an unworkable position right now. So I would say to those on the other side, it isn't about 27 nations hating the UK, it ultimately is about function. And here is the point, that Sir Jonathan Fall, who was the Director General of Internal Market Service Directorate at the EU, ended up as Director General of the Task Force for Strategic Issues related to the UK referendum, and his team came to a very simple conclusion. The only way to make this workable was to have what is essentially in this bill. That is exactly what he has now put a statement out today to say. So it is practical, and those who knew and understood the difficulties at the time said there was a way to do this, but they were ignored.
Yes, and the right honourable gentleman is absolutely right. And those of us who are looking for a solution are supporters of this bill, because we can't go on as we are. Those who think that it's okay to subjugate part of your own territory are opposed to this bill. They are quite content with the colonisation of the part of our territory. And of course, in constitutional terms, where we have ended up, Madam Deputy Speaker, where we've ended up is Northern Ireland is no longer a full part of the United Kingdom. Why? Because of the fact that in 300 areas of law we are not our own masters. Because of the fact that a foreign jurisdiction makes those laws. What does that create? That creates, in constitutional terms, what's called a condominium, ruled in part by UK laws and in part by foreign laws. The Honourable Lady finds that hilarious. Sorry, it's not hilarious if you're subject to that particular situation.
You do it all the time.
I'm going to give way to the front bench spokesman who first asked on the Conservative side.
No, he wasn't on.
Oh, sorry, he was. I misunderstood. Yes, I'm glad to give way.
The honourable gentleman giving way. I have to say, I find myself surprised to agree in agreeing to an extent with the former leader of the Conservative Party, in that we need to move away from some of the ridiculous extreme language. There is no reason, is there, why the European Union would want to colonise Northern Ireland. Are we not talking about a sensible agreement which does not seek to impose sovereignty, but instead seeks simply to avoid a hard border on the island of Ireland, to safeguard the Good Friday Agreement in all its dimensions, at the same time protect Northern Ireland's place in the UK and in the UK's internal market? Should we not recognise that and stop using extreme language which does nothing to take the debate sensibly forward?
essence of this bill is to restore equilibrium, to get us to the point where we have a sensible relationship based upon mutual respect, not on grabbing the sovereignty one of the other. And that is where we've got to. The honourable member may not like to face up to it, but when you have a situation that a whole raft of jurisprudence and lawmaking has been removed from within the reach of this United Kingdom and placed within the control of a foreign body, then that is not the basis for a sustainable solution. And that is why I've given way quite often. I'm going to make some progress if the House doesn't mind. That is why what I regard as the two liberation clauses in my bill, clauses 5 and 2, exist. They are the clauses which will free this whole United Kingdom, and Northern Ireland in particular, from this malevolent situation where a huge portion of our laws are made not by ourselves but by others. And that is very, very important. Now, I've spent a lot of time this morning talking about the constitutional import of all this, and that is very important because it is really that which gives certainty and assurance to any part of this United Kingdom. But, and just before I leave that, I remind the House that because of the protocol arrangements, our Supreme Court had to rule that Article 6 of our Acts of Union, that which guaranteed unfettered access between and within in trade all parts of the United Kingdom, that because of these protocol arrangements, that article stands in suspension. Now, you can't get it from a higher authority than the Supreme Court to demonstrate that a key component of the very act of union that makes this union is in suspension. And if it's in suspension, and the cause of it for being in suspension is the protocol or Windsor framework, then no one who believes in that union should be sanguine or at ease with that. But there are also economic consequences to all of this. Before Brexit, Northern Ireland had a very integrated economy with the rest of the United Kingdom. Free, unfettered flow of goods, one way and the other, as you would have from Birmingham to London or to Edinburgh, and still have. We had exactly that. Yes, I could.
Member for giving way to me on this point. He mentioned earlier about certainty. He has just mentioned now about the impact on the economy of Northern Ireland. But wouldn't he agree with me that bringing in a bill like this, which would see regulations change in Northern Ireland for business in the space of potentially just 3 months, that would have a massive impact on businesses in Northern Ireland, a huge impact on the economy of Northern Ireland, and is not what businesses need right now?
It's exactly what businesses need. My constituency office is choked from time to time with businesses saying, why is it I can't get the goods I need without all this paperwork, without all this bureaucracy? And let me say, there are many small businesses in my constituency and elsewhere, maybe small engineering businesses. They rely for their raw materials not on huge containers of raw materials coming in, but on parcels of boats and everyday materials which they come maybe 6, 7, 8, 12 a week. Come the 13th of December, the Irish border is going to extend to a parcels border. Early next year, to a parcels border. And we're going to have a situation where those businesses which rely on the daily arrival of a parcel of some raw materials from GB are going to be put through the red lane of this full blown international customs border. Now, the Honourable Lady may think that's good for business. I have to say to her, that is a death knell to business. And that's the problem we have. So the economic consequences are severe. Our raw materials, even with the Windsor Framework, all our raw materials that feed all of our manufacturing industry, that come from GB, now have to pass through the red lane full international customs border. Now think of that, of the effect on a business. And that is what is stifling, not growing business. In consequence, we've had trade diversion. Of course we've had. We have veterinary medicines. No, our veterinary medicines, in the main, come from GB. Always have. But now, we're facing a cliff edge where, according to EU diktat, they can no longer come, because we're subject to the EU's veterinary requirements, not the United Kingdom's. And medicines we've used in safety, with no problems, for decades, are suddenly to be stopped. The government says they're going to get a deal. Well, let's see it. But even the very thought that you have to go cap in hand to a foreign power to say, please, could we have an arrangement where from within our own country we could bring our own medicines to another part of our own country? Please, could we do that? That is so humiliating at a national level, but so prejudicial to our farming community. I'll give way.
Thank you again for giving way, and you continue to speak with passion. The issue around medicines is really interesting, and I know you've been speaking at some length already, but it'd be useful if you could outline some of the medicines that won't be prohibited, that will be prohibited, and what the alternatives will be to them. Thank you.
Well, there are medicines. There are human medicines and there are veterinary medicines. The vast swathe of veterinary medicines presently stand to be prohibited. In human medicines, there are still medicines which affect diabetics, which are subject to difficulties. And the honourable member, who was the health minister in Northern Ireland, knows all about that, and I'll gladly give way to it.
The honourable member gave way in the fact of that point. I know the member sit and smile, and I'm actually quite concerned, Madam Deputy Speaker, with the attitude of some of the other benches in regards to this issue. In regards to the human medicines, there was a serious piece of work that had to be conducted with the European Union in regards to continuing the supply of human medicines into Northern Ireland. And the challenge is not in the fact in the legislation, but the producers and suppliers actually meeting the requirements of the European Union of having to have specific Northern Ireland labelling, which makes it not worth their while to supply Northern Ireland. So as an outworking of what is being required of these legislations, of these requirements, as manufacturers are stopping producing Northern Ireland.
Yeah. And the honourable member knows that from experience. Yeah. I do want to make some progress, but I do want to make this point very strongly, that the economic consequences are dire for Northern Ireland. We've heard much talk, what I would call, about the fantasy of dual access bonanza. We had those tell us Northern Ireland was going to come the Singapore of the West. We now had unrivalled access to the UK market and to the EU market of 500 million people, and everyone should be overwhelmed by the fantastic opportunity that is. How wrong it has turned out to be. And for one very simple reason, already alluded to by the right honourable member for East Belfast. Yes, we have the suggestion that inward investment will flow into Northern Ireland because you have this dual market access. But it hasn't. Invest and I have had to admit there has been no upturn, And why is that? Because any benefit, if there is one, is countermanded by the fettering of the trade from GB. If you're a manufacturer coming to set up in Northern Ireland so that you can have access to the EU market, you're bound to think to yourself, because investors are intelligent people, you're bound to think to yourself, where am I getting my raw materials? Oh, I'll get them, as most do, from GB. But then when you discover that to get those raw materials, they must pass through an international customs border with all the regulation, all the delay, all the inspection, all of that, then the shine soon goes off the fact that it would be good to set up in Northern Ireland. So far from being this bonanza, it has turned out to be anything but. And I've made the point already that the one sector which is flourishing is services, and it not just happens to be, but because it's outside the protocol, has the ability to flush it. And things will get worse. Next Friday, when the General Product Service Regulations come into force, many small suppliers will simply stop supplying because of the bureaucratic burden that is going to be placed upon them. We already have so many items. If you go to buy it online, it will pop up, not available in Northern Ireland. Why is that? Because the small suppliers from GB find it impossible to handle the burden of bureaucracy. So they simply say, we're not supplying to Northern Ireland. And that is something which frustrates so many people in Northern Ireland. When you go to order something, not available in Northern Ireland. It's a huge frustration for many, including, I might say, Mrs. Allister, who, like many's a woman, wants to order things and finds not available in Northern Ireland. How would honourable members of this House from Great Britain feel if it constantly popped up, not available in Scotland, not available in Wales, not available in England? Wouldn't they be asking why? And when they asked why and got the answer, it's something called the protocol, why would they then continue to be enthusiasts for the very thing that's blocking their consumers from getting the supplies they need? That is a practical issue. Yes, okay.
Thank the Honourable Gentleman for giving way and commend him on his passion. But his problems are not unique. Anywhere in the Highlands and Islands of Scotland, or even in the periphery of other parts of England, have the same delivery problems as he does.
Ours is the delivery problem, Madam Deputy Speaker. Ours is a bar on the sending. Ours isn't that it's just too difficult. Ours is that it's too difficult because of the international customs requirements. That's the difference with the Highlands and Islands. And I'm sure they do have that problem, and I'm sure small businesses do shirk the desire to serve them. But in Northern Ireland, it's for a more fundamental and compelling reason. I want to move on and come to Article 2. Yes, okay.
The frustrations that the member talks about surely is a good argument for what the current government are trying to do in resetting the relationship between the UK and the EU. And therefore, surely this bill will only undermine the credibility of the UK in doing that, and with our international partners. Does my honourable friend agree that we need to be keeping focused on the issues going forward, rather than going all over these points again?
This bill is prospective in all its tone and purpose. It is about going forward. It's about solving the problem which has been put upon us. And you know, the honourable member says, "Oh, let's reset." Well, for some, of course, that's let's rejoin. That's a matter for those who are advocating for that. It's certainly not where I'd like to see this United Kingdom go. But yes, we do need to reset. But we need to reset on the basis that Brexit is for all, not just for some. And when you reset it on that basis, then you won't have me constantly raising these issues, because I will have the equal citizenship that's been denied to me and my constituents by these arrangements. This fundamentally is an equal citizenship issue, and it is quite appalling and insulting to many people in Northern Ireland that they are thought they should be treated differently, denied the equal citizenship of the rest of the United Kingdom. I need to come to Article 2 of the protocol. It's already been alluded to in one intervention. Article 2 of the protocol, which the government a couple of nights ago said they're going to appeal the findings in one of the cases in Northern Ireland. Though listening to the Secretary of State for Northern Ireland, I think it's a pretty half-hearted appeal in that regard. Article 2 of the protocol shows us that it is not just about trade. That was the initial selling point of the protocol. Oh, it's only about trade. But now we've discovered, through Article 2, that it has a most pervasive effect on all sorts of things. We've had recent legislation in the last Parliament which has been overturned in its application in Northern Ireland. Why? Because of Article 2. Now, whether you liked or disliked the Rwanda Bill is not the point. The point is that our High Court and Court of Appeal have ruled that the provisions in the Rwanda Bill could not be operated in Northern Ireland. Why? Because of Article 2 of the protocol. Why is that? Because Article 2 subjects Northern Ireland to the EU human rights provisions, not the UK human rights provisions, and protections which exist for asylum seekers under EU law, therefore would prevent the measures that were taken. It's not about the debate of the merits or demerits. It's about the constitutional fact that a bill of this House, the sovereign will at that time of this supposedly sovereign Parliament, could not be implemented in a part of the United Kingdom because of the supremacy of EU law. That is the... No, I'm going to finish this point. That is the fundamental issue here. And, of course, we also had it on the legacy bill. Again, it's not about the merits or the demerits of the legacy bill. Much of it I abhorred, but it's about the principle that our courts in this United Kingdom ruled the provisions of this Parliament, the sovereign will of this Parliament is overridden by the laws of a foreign jurisdiction. That is the fundamental issue of sovereignty that is at stake here. And that is why this bill, at Clause 2.7, will address the import of Article 2 by making it something which cannot be given effect in domestic law. I'll give way.
I hope he will recognise it's not laughter on this side, it's bemusement at the inconsistency. See, the member opposite... The member opposite opines about his anger that a third party can make law in Northern Ireland. Of course, many of us tried to untangle the inconsistencies in the Rwanda legislation. The member for East Belfast and I tried in vain to raise it with the previous government. The critical issue was about the right to remedy and the rights it gave people in Northern Ireland to petition a third party if they thought their government was overbearing on their own basic rights. Now, he himself has used these rights. Why is it with this legislation? He's used those rights himself. He's chosen to go to the Supreme Court. That's why we're here today. He's not chosen to go to the court in Strasbourg, which would be his right, and I would support him in doing so on this. But why would he deny the right to remedy to the rest of his fellow residents of Northern Ireland, as this legislation would, when he's saying he thinks it was wrong for that right to be protected by the Court of Human Rights in the first place?
Can I remind members that it is up to the member who is on their feet whether they want to accept an intervention? Jim Allister.
I have been very generous in giving way, and in a way I'm not assisting my cause, because I know the members opposite want to simply talk this bill out. I would rather see them take a stand on whether they're for or against the subjugation of sovereignty within the United Kingdom. But so I am going to move on and deal with these issues. The honourable member referred to me taking a case to the Supreme Court. Yes, why wouldn't I? It's the Supreme Court of my United Kingdom. Why wouldn't I take a case to the Supreme Court and test the laws which relate? And I remind the House again that what that Supreme Court had to hold is because of the protocol so enthusiastically supported by members opposite. Northern Ireland's place in the United Kingdom has been subjugated because the Supreme Court held that the fundamental building block of Article 6 of the Acts of Union is in suspension because of the import of the protocol. Now, some tell us, well, we don't want to face these issues. There's no option, we're told, because of the Belfast Agreement. I've even read, I've heard people say, oh, the Belfast Agreement prohibits a border on the island of Ireland. I hold it in my hand. I've read it many times. Perhaps someone could direct me. Where in this document does it say there cannot be a customs border on the island of Ireland? Where is it? It isn't there. We've already got a currency border. We've got a VAT border. We've got a tax border. Nowhere in the Belfast Agreement does it say that you can't have a customs border at the international boundary of the United Kingdom. Nor should it. And then I'm told, oh, this would breach international law if you didn't have the protocol. That's not correct either. A fundamental premise of international law is respect for territorial integrity. What have I been talking about for the last hour if it hasn't been about territorial integrity and the respecting of it? And that is the fundamental premise of international law, because it all goes back to the General Assembly of the United Nations resolution, Declaration on the Principles of International Law. And what does it say? It says territorial integrity is key. And it says this: this declaration constitutes the basic principles of international law. It says every state shall refrain from any action of disruption of the national unity and territorial integrity of any other state. If only that had been adhered to. It says that where obligations under international agreements are in conflict with the obligations of this Charter, the obligations of this Charter shall prevail. So the fundamental is respect for territorial integrity. That is the governing principle of international law. So when an agreement such as this comes into play, which defies that fundamental requirement for respecting territorial integrity, then it is that falls, not international law. No, I'm going to make progress. So I strongly refute the fallacy that to depart from the Windsor Framework is to breach international law. On the contrary, Madam Deputy Speaker, to perpetuate the infringement of our territorial integrity is to breach international law itself, and indeed the Belfast Agreement, which was built upon consent, of which has been none in respect of these arrangements. The correct application of international law is to the effect that agreements which contradict the regulating principles, including respect for territorial integrity, are themselves the villains of the peace. Let me come, having set out everything that's wrong, to the solution. The government has always told us you cannot conduct SPS checks away from the border. It can't be done. So you must have a border, in our case, in the REC. But this week, a statutory instrument was put before this House which does exactly that. It does it for goods which are coming from the EU via Northern Ireland to GB. And it says you can check those goods wherever they arrive, at factories, at premises. You don't have to check them at the border. Now, if you can do that for GB goods coming through Northern Ireland to GB, why can't you do it in reverse? Of course you could. Of course you could check goods without a tampering with sovereignty. You could do them anywhere within the territory of the United Kingdom. So it's not the impracticability of carrying out the necessary checks that's the problem. It is the fact that under the surrender of sovereignty, they've been insisted on being carried out in the REC border. And that brings me to clauses 6 to 18 of this bill, and the concept that they would permit of mutual enforcement. Now, I readily accept that clauses 16 to 18 draw heavily on the Protocol Bill of 2022, which found the approval of the previous House. Of course they do. But they're none the worse for that. And what they do is very simple. They say that two respecting neighbours, that's what I hope we are, the United Kingdom and the EU, who with the necessary trust between each other can operate a system where they mutually check the goods flowing from their territory to the recipient territory to ensure that they meet the standards of the recipient territory. That is a fundamental tenet of much of international trade, and it is something that can be built upon in respect of this matter. That the United Kingdom says, yes, we know the EU wants to protect, they tell us, their single market, and yes, we want to protect our single market, so we will, in a moment, we will undertake, by virtue of criminal sanction for those who don't, we will undertake to check that goods flowing from our factories to your consumers, from our territory to your territory, meet the standards that you set. And we expect you to do the same. And that can be done without all the paraphernalia that we presently have. Yes, sir.
On this particular point, it's also worth pointing out that the EU already does it. So in their agreements with New Zealand, for example, they trust veterinary practices, specific veterinary practices, to check lamb and other products arriving in the EU at the point of departure. By the time it gets to Rotterdam, it's cleared straight through on the basis that they respect the checks that were done by those veterinary companies. And they were doing it for years, for 40 years, with UK companies already, where any subsequent checks had to be done. So all of this is already being done. The question is, why is it not being done for this arrangement that we have at the moment?
Absolutely agree. And the fascinating point about all of this, the very concept articulated and was originated within the EU itself. Because during the early stages of the negotiations, Sir Jonathan Falls and two academics, Daniel Sarmento and Joseph Wheeler, came up with this proposition. It's not my proposition. It's not a United Kingdom proposition. It was an EU proposition. And they said, this is the answer. Mutual enforcement. And today, we have a statement from those three gentlemen, which has been made public. I'd like to read it to this House. On Friday of this week, the House of Commons will be debating a bill which attempts to address some of the difficulties resulting from the Brexit divorce agreements between the EU and the UK, which might be of interest to readers. In 2019, we proposed a solution which would have obviated any need for these complicated and divisive legal manoeuvres. The UK and the EU could have respected each other's positions and saved everyone a great deal of time and effort. The Financial Times characterised the proposal as a win-win solution. Regrettably, these three gentlemen say, it was not followed. And I would echo that. Regrettably, it was not followed. Why was it not followed? Because the politics took over. Instead of looking for a workable, practical border solution, the politics of making the United Kingdom pay for leaving the EU took over. And that's how we got into this morass of a pernicious imposition through the border. Yes, I give way.
During the early stages of the negotiations, the Permanent Secretary of the then Brexit Department told the committee in a meeting that the Irish government, before Leo Varadkar took over, was actually exploring those kinds of solutions, and the politics of the changeover in the Irish Republic and the willingness of Leo Varadkar to become the puppet of the EU in these negotiations stopped that very method of looking at the border.
I fear there's a lot of truth in that, and I think there's further truth. I said about the politics took over. And for some, not all, but for some enthusiasts about the protocol arrangements of a nationalist or Irish Republican persuasion, there is a political gain here that subsumes all doubts they might have as Democrats. And it is this, that for 30 years and more, the IRA terrorised through bomb and bullet to try and push the border to the Irish Sea. Brits out, push the border to the Irish Sea. That is precisely what the protocol has done. It has pushed the border to the Irish Sea. Now, the honourable member for South Belfast may, from a sedentary position, object. But the challenge to the honourable member for South Belfast is her nationalism more important to her than her democratic credentials? How can, in a moment I will give way because I've mentioned it, how can the honourable member who calls herself a social democratic and Labour member, how can she look her constituents in the eye and say, I believe you are not worthy to have your laws made by those you elect, and I would rather they're made by those you don't elect? Is it because the nationalist reach of the protocol is more important than the democratic detriment of the protocol? Yes, I'll give way.
If the member wants to talk about constitutional change, perhaps he might set out for the Chamber the numbers and the level of support for the Union before and after he began his Brexit adventures. The member will know that I, as a Democrat, constitutionally compromise every single day because I am a Democrat and I am an adult and I live in a constitutional reality that is not as my choosing. I'm an Irish person living and working and upholding democracy in the United Kingdom. The member will also know that none of his arguments about democratic deficit stand in any way when his campaign suppressed the Northern Ireland Assembly, the legitimate expression and place of primary lawmaking for Northern Ireland, and when he created an enormous health sea border in the Irish Sea. His adventures, his hobby horses, have created a scenario where 1/3 of the population of Northern Ireland is on a health waiting list. I and others who don't like exactly the way our constitutional arrangements are made stand up every day and work to solve those problems. All he wants to do is create them. It is his actions, in fact, that are inserting the dynamism in the question about constitutional change. Every time he pulls a stunt like this, he drives more people to seek to get out of the control of men like him. I, as a Democrat, every day uphold I accept the constitutional reality. I accept we're members of the United Kingdom. I'm seeking to change that democratically, so he will never again question my commitment to democracy in Northern Ireland.
I acknowledge the honourable member's speech, but let me say, it is no stunt on behalf of my constituents to ask for them the same as every other part of this United Kingdom has, the right to be ruled by the laws we make ourselves. It is no stunt to ask for equal citizenship. It is no stunt to say that this United Kingdom, the clues in the title, should not be partitioned by an international customs border. So I take, when I've dealt with some other points, it is an assault upon the sincerity and the efficacy of those who would dare to say, if we're part of the United Kingdom, then we need to be treated as part of the United Kingdom. And the Honourable Lady did not explain to us how she thinks it's right to disenfranchise her own constituents and to reject a workable, practical solution. Those who reject a workable, practical solution are those who don't want a workable, practical solution in respect of the Irish border. And I think that that is fairly clear from that particular intervention. Yes, I give way to the Minister.
I thank the honourable member for giving way. Several years ago, the former Prime Minister, Boris Johnson, told us there was an oven-ready deal here, and that was clearly not the case. We're still here discussing this. and the honourable member have discussed mutual enforcement. But nowhere in the world does mutual enforcement happen in trading regulations wholesale between countries. So the only workable deal has been worked out not by politics but by pragmatic working out, and that's the Windsor framework. So is he selling something which actually cannot work? This mutual enforcement idea has been described by the EU Commission as magical thinking.
And I remind the Right Honourable Lady, the very magical thinking came from the EU itself. Yeah. So Jonathan Falls and his colleagues were those who articulated this very suggestion. And why wouldn't it work? If the EU is our friend, if we trust them, if they trust us, would they not trust us to keep our word in terms of imposing their standards on our goods that are going to their territory? Why wouldn't they? And if it didn't work, then is the time to talk about alternatives. But it should be the starting point, instead of this whimsical dismissal that it wouldn't work when it's never been tried in respect of this situation. And that is, and the really chilling thing about the Minister's intervention is that the subtext is, suck it up, Northern Ireland. You're no longer a full part of the United Kingdom. You will just live like a colony of the EU under their laws in these 300 areas. We have no empathy. We have no desire to fix it. We're just going to leave you in that position. That is the chilling import that I take from the Minister's intervention in that way. Yes?
I'm most grateful for you giving way. Would it be helpful to remind the Minister that actually the EU's own expert, Mr. Lars Carlson, in his report, Smart Borders 2, said with technology and goodwill, all of these issues could be overcome, but the politics of Mr. Varadkar and the EU overrode that.
I think that's absolutely right, and we're reaping those aggressive political agendas today, and we reap them every day in Northern Ireland because of this. And if the government is saying that this is fine, there's nothing to see here, we don't need to fix anything, then frankly they are not just insulting the intelligence of those of us who have brought this bill, but they're saying to my constituents, you can carry on being second-class citizens. And that is the import. You cannot say to my citizens, you're equal citizens, but you'll not be governed by British laws. You cannot say that. And that is what the government is saying. To my constituents in North Antrim and everywhere across Northern Ireland, you have equal citizenship, but some are more equal than others. Some will be ruled by the laws this Parliament makes, that evolved assemblies make. But you, no, you'll be ruled by the laws that someone else makes for you, and be grateful for it. You know, that is where we've got to on this issue. And that is not just insulting, it is unacceptable, frankly, that the people of Northern Ireland should be treated in this way. The other thing I'd say to the government is this. In their enthusiasm to maintain the unworkable status quo, they maybe should just reflect on the fact that there's about to be a new president in the United States. And that new president of the United States has made it very, very plain that he's in tariff mode. And if he carries through on his tariffs, then this government in this United Kingdom will need a trade deal. And why would a president of the United States do a trade deal with the United Kingdom if that United Kingdom's back door is open into the EU? And that is the consequence of this protocol. You do not have a secure international border in terms of trade. You have a border that is porous into the EU. And if Mr. Trump, by all reports, is pretty adverse to the EU, why would he ever do a deal with the United Kingdom with that back door open? So shouldn't this government be taking this opportunity of this bill to say, right, we're going to fix it, and then we can convince the Americans that we are a safe and secure partner in a trade deal? Because so long as this protocol exists, then that certainty cannot be given to the United States of America. And I think it therefore is in the national interest, it's in the government's interest, it's in our trading interest to fix this arrangement so that we can, on the best possible terms, can pursue a trade deal with America, who at the end of the day are our best friends in all of this. I'll give way over here.
Thank you. You've already outlined 300 areas of tightly bound areas where the EU influences Northern Irish legislation. But it sounds very much as if you're suggesting now that the United Kingdom should be operating under the whatever remit the President-elect of the United States is choosing to set for us. Policy is made here in Parliament. It is not made in DC.
I only wish it was made for Northern Ireland in this Parliament. I only wish that the laws for Northern Ireland were made in this Parliament or in our devolved institutions. Surely the honourable member, if he's been listening at all, has understood that there are these vast 300 areas of law which are not self-contained. They are expanding. They've already been expanded, which are made in a foreign Parliament. That's the fundamental. And if he doesn't understand, if the member doesn't understand that if you want a trade deal with the United States, then you have to show that a bona fide trade deal will be with the United Kingdom and not as a surrogate with the EU through the back door, which is wide open into the EU. Yes?
I thank the honourable member for giving way, although I do note that he failed to answer the question from my honourable friend. But he talks about doing a deal with the United States of America on trade. How could we possibly be taken seriously as a trade partner by any country in the world in the future if we are to break the deals that we already have on the table? How could that possibly happen?
Sorry. If the deal was reached under false pretences, if it was reached in breach of international law, because it breached respect for territorial integrity, then the first thing this government should do is, yes, reverse that arrangement, because they should not be continuing with a deal which does not respect the territorial integrity of this United Kingdom. That's the fundamental principle of international law. And if that fundamental principle has been disregarded to get this arrangement, then this arrangement is disreputable and not worthy of continuation. That's the fundamental. And that, I would have thought, is going to be of more interest to our American friends than a deliberate attempt to say, oh, we will make a deal which will sell out some of our own people, which will create circumstances where we will benefit the EU through the back door of any trade deal we do, and yet, please, Mr. President, make a deal with us. It's not going to happen, and I think the government knows that and needs to realise that. Can I try and draw my remarks to a conclusion by taking the House to Clause 19? Clause 19 seeks to reinstate the fundamental operating principle of the Belfast Agreement. Fundamental operating principle of the Belfast Agreement is that every key decision in Northern Ireland, because of our divided and troubled past, should and must be on a cross-community basis. It's there in black and white in the agreement. And yet next Tuesday, the most key decision that the Northern Ireland Assembly has ever taken comes before it without the need for cross-community consent. And the decision, in a moment, the decision is that Northern Ireland should continue in these 300 areas of law to surrender its law-making powers to a foreign parliament. There is nothing more fundamental either to the constitutional status of Northern Ireland or to the governance of the people of Northern Ireland than that. And yet, to ensure the outcome that was wanted for that vote, a move was made to remove, especially for that vote, the cross-community requirement. So that for the first time in over 50 years, we're going to have a majoritarian decision of considerable import taken in Northern Ireland. That is a rigging of the arrangements of the Belfast Agreement. And strange as it might be, I today, in this bill, am the one championing the requirements of the Belfast Agreement by saying, if the modus operandi is cross-community support, then why is the vote being rigged to remove cross-community support? One might have thought, and I'll give way to her in a moment, that the honourable member for South Belfast would have been the champion of the Belfast Agreement and wanted to ensure that its fundamental operating principle of cross-community support was respected. But no, she and her party are those who are cheerleading for this very vote and brought it to the Assembly when the Executive failed to bring it to the Assembly. So it is an important point. It is a point that cuts to the very operation and stability of the Belfast Agreement, that for the first time a key decision is to be taken not on the prescribed cross-community basis, but on a majoritarian basis. What does that say to me and my community? It says, you don't really matter. You don't really matter. Because it's more important we get this vote through. And cross-community, that was about protecting nationalism. It's never about protecting unionism. Oh, sorry. We call that in today. And we say if it's good enough for nationalism, it should be good enough for unionism. And why? Why is this government, why is this House trying to say to unionism in Northern Ireland, you don't matter on this issue. We will railroad this upon you. That's the fundamental. I give way to
the member's position that the fact of Brexit doesn't require cross-community consent, and the fact that on the 8 elections since Brexit, the people of Northern Ireland have rejected Brexit, but that the protections require cross-community consent. Is that not consent for thee but not for me? And can I confirm that the member does now, with the inclusion of this provision, support the Good Friday Agreement 26 years after repudiating the will of 71% of the people?
Brexit was a national vote, decided for better or for worse on a national basis. People of London didn't vote for Brexit, but no one's saying they should now be ruled by laws from Brussels. People of Northern Ireland, by a small majority, didn't vote for Brexit, but members are saying that we should be ruled by laws from Brussels. That does not stack up. I'm simply calling in aid what the Belfast Agreement says. And the Belfast Agreement says key decisions cross-community. Is anyone denying this is a key decision? If so, why is it not a cross-community vote?
And I thank the honourable member for North Antrim bringing this point, and I do acknowledge his recognition of the strengths of those protections that were actually built in by my party in the Belfast Agreement, and especially by the Lord Trimble, the former leader of the Ulster Unionist Party and the crafter and the political deliverer of unionism and the support of the Belfast Agreement at that time. But he said, and I quote him, "I feel betrayed personally by the Northern Ireland Protocol, and it is also why the Union's population is so incensed at its imposition. The Protocol rips at the very heart out of the agreement, which I and they believe safeguarded Northern Ireland as part of the United Kingdom and ensured that democracy, not violence, threat or violence, or outside interference would or could ever change that." He says, make no mistake about it. The Protocol does not safeguard the Good Friday Agreement. It demolishes its central premise by removing the assurance that democratic consent is needed to make any change to the status of Northern Ireland, and embodies a number of constitutional changes that relate to Northern Ireland.
Yeah, and the late Lord Trimble was absolutely right about that. And what is happening on Tuesday is an invitation to the Assembly, courtesy of the government's directive, to tear up that key central portion of the Belfast Agreement of cross-community consent. And there is another point here. Yes, I'll give it.
The honourable member, thank you for giving way. He talks about the Good Friday Agreement, but why does his bill not guarantee that the institutions of the Good Friday Agreement have powers? And why is he happy to put those in terms of the UK government ministers, unlike the existing arrangements under the Windsor framework?
Sorry, my bill is about seeking to restore democracy to the arrangements. That's why I want to take back from Brussels control over our laws. So my bill is a charter for democratic progress. The present arrangements are the antithesis of democratic operation.
I'm very grateful. He might not have supported the Good Friday Agreement, but doesn't he acknowledge the fact is what that agreement did was recognise the sovereignty of the United Kingdom in Northern Ireland. It involved the changing of the constitution of the Republic to recognise the sovereignty of the UK in Northern Ireland for the first time, and it also recognised the reality and the existence of a border on the island of Ireland. So what he's actually doing is reinforcing the principles of the Good Friday Agreement, which he himself might have opposed back in the day.
And the core operating principle, as far as the devolved institution in Northern Ireland is concerned, was key issues, cross-community consent. That's what has been ripped out for Tuesday. Now, I've yet to hear a rational, convincing explanation for that. Maybe the Minister has one. Why is it that we have ripped out of the heart of the Belfast Agreement the very thing that was supposed to give comfort to both sides, that neither side would pull one over on them? Why have we ripped that out of this agreement? If the Minister wishes to tell me, I'll gladly give way on that point. But there's even a further point about this vote on Tuesday. Article 18.2 of the protocol said the consent vote, when it came, was to be reached strictly in accordance with the unilateral declaration of the UK Government of October 2019. Strictly in accordance with. That unilateral declaration of October 19 promised, before this vote, a public consultation. It's there in black and white in the words of the declaration. There has been no consultation. So why is the government inviting the Assembly to conduct a vote which breaches the guidelines that were laid down by the very protocol itself, that the consent vote should be strictly in accordance with that declaration? And that declaration included the promise of a public consultation, of which there's been none. So that's another question for, well, I'd rather give way to the Minister on that particular issue. But I hear no answer to it. So, Madam Deputy Speaker, the House has been very patient as I have laid out the arguments for this bill. I see this bill as an opportunity to restore the equilibrium that I hope I've demonstrated has been destroyed in these arrangements. The democratic equilibrium, the equilibrium of equal citizenship, the equilibrium of Northern Ireland's place within the United Kingdom, and the equilibrium of our relation with the EU. All those are positives, all those are in the national interest, and all those are that which I believe should recommend themselves to this House. I trust the House will give favour to this bill. Thank you very much.
Yeah. The question is that the bill be now read a second time. I call Peter Dowd.
Thank you. First of all, Madam Deputy Speaker, can I say it's a delight to see you in the chair today. And I'd like to thank the Honourable Member for North Antrim for giving the House the opportunity to debate the contents of his bill as set out in its 25 clauses, and the issues, of course, that surround it and which have clearly been the subject of consternation, to say the least, in some quarters. And I listened very carefully to the many points and assertions that the honourable gentleman made, and no doubt everybody in the chamber listened to them. And I don't underestimate the significance of the concerns, perceived, real or otherwise, that he and many others have in relation to the operation of the Windsor Framework, which was, in effect, successfully negotiated, as shall I put it, a recalibration of the Northern Ireland Protocol. And there is no doubt, it has to be said, that all sides worked hard to achieve an agreement, given the obvious complexities, nuances and tensions that were bound to arise when the implementation of the decision to leave the European Union was made in the light of the 2016 referendum. And I believe the detailed statement made by the last former Prime Minister and the response to it and questions about it on the 27th of February 2023 set the tone, in my view, and I think the view of many other members, for a genuine attempt on all sides of the negotiation to be as flexible as possible given the circumstances. And I want to quote one or two points from that particular statement, that debate. The Prime Minister at the time said, "Today's agreement has three equally important objectives. First, showing trade to flow freely within our UK internal market. Secondly, protecting Northern Ireland's place in our union, which we all agree with and we recognise. And thirdly, safeguarding sovereignty and closing the democratic deficit." And he went on to take each of those in turn in more detail. And then later on, he talked about today's agreement scraps 1,700 pages of EU law, which is being referred to today. And I'll come back to that again in due course. He sort of went on to say, the EU has also explicitly accepted an important principle in the political declaration. It's there in black and white that the treaty is subject to the Vienna Convention. This means, unequivocally, the legal basis for the Windsor Framework is in international law. I would like to thank my honourable friend, and he went on to talk about the member concerned. Then it's important to move on to the current Prime Minister, who was then the leader of the opposition, and what he said. And this is important as well. This agreement will allow us to move forward as a country rather than being locked in endless disputes with our allies. Now, who wouldn't agree with that statement? We don't want to continue to be locked in endless battles and arguments with our allies. And another honourable member at the time, and it's worthwhile referring to this, which was the member for North Dorset, he said, "My right honourable friend, the Prime Minister and his ministerial colleagues have strained every sinew these last weeks and months to arrive at today's positions. They are to be congratulated." And I think that's important from the other side of the House as well. And of course, the current Secretary of State for Northern Ireland said, I congratulate the negotiators on this very significant achievement. And it was an achievement. And even the member for Halton, Price and Howden said, "I start by unreservedly congratulating my honourable friend on what seems to be a spectacular negotiating success." And I will finish in this particular element from the former member for Clwyd West. I will.
I just listened to your speech, to the honourable friend's speech with interest, and can I just say that does he agree with me that this contribution shows that there is space for fulsome debate and an important democratic scrutiny of these things that affect our family of nations?
My honourable friend is right on that case, and that's why so many of us here today want to discuss this particular issue, because it is crucial to talk to our constituents, not just in the short term, but in the longer term. And can I just finish this point, and then I will give way to the honourable member. And of course, the former member for Clwyd West said, the common command paper tells us that the framework, quote, narrows the range of EU rules applicable in Northern Ireland to less than 3% overall by the EU's own calculations. Now, again, I'll come back to that. I'll give way to the...
So the honourable member has recited to us many what some might have thought were erudite contributions in support of these arrangements. Apparently, with the intervention towards the end, that therefore, we have considered all this matter. Has the honourable member's friends not spent since July trying to undo the very things that the previous government did on so many other matters because they thought they were wrong? And if they were wrong in this, should they not be trying to undo this?
I don't quite understand the point that the honourable member is making. What we're trying to do today is to tease out many of the issues that he, quite understandably, has raised in his concerns, and for us on this side to try and understand those concerns and maybe to reflect on them and, in future, give consideration to them through the processes. But it's important that we are all here today listening to what he has to say and what other members have to say. I will.
I thank my colleague for being away. There is also something very important here, is that this House was charged, along with the Irish government, to uphold the Good Friday Agreement. That means in any legislation that comes along, it is right and proper for us to ask how we do that role in this place, alongside our colleagues across in Ireland. And this legislation touches on so many elements of it that today's debate is also about us doing the important job we pledged all those years ago to do to improve and maintain peace and stability in Northern Ireland.
Yeah. My honourable friend is absolutely right, and I would be the first to admit that we don't always get these things right. Whoever does get these things right, but what we have to do is try again and attempt to do our best in good faith, and I will come back to that in a moment. I will give way to the
member for giving way, and he has quoted some of the comments that were made in this House. But would he accept that the two people who negotiated the very things that he's referring to and which those comments were made about, one thought he had signed up to an agreement where there'd be no paperwork, and if there was any paperwork, he simply told people, tear it up, it doesn't matter. And the other one negotiated an agreement which, when the EU version of it came out, was totally different from the version which he gave to this House and which he gave to the people of Northern Ireland. So let's not fall back too much on the comments that were made about either the two agreements at the time, because I think that many of them were made either with lack of knowledge or with hope that never was fully founded.
Well, I understand the comments that the honourable gentleman makes, and I'm not going to challenge the integrity of the people who were part of that negotiation. It's not for me to challenge their integrity. They're honourable members, and I believe that they did what they did with the best intention. But at that statement on the 27th of February, I believe on the whole, during the statement, most comments were supportive, and I acknowledge and accept that some weren't. I think from the honourable gentleman himself, he made his views known, as did others, and I acknowledge that some of those members who spoke in that statement are in the chamber today, and they expressed disquiet. And I do welcome the fact that they've taken their places on the bench today, Madam Deputy Speaker. But their disquiet and others' disquiet must be set in the context of the following, namely the agreement according to the command paper, which is important, and I referred to this area, narrows the range of EU rules applicable in Northern Ireland to less than 3% overall by the EU's own calculations. Now, I think in any negotiation, in the circumstances, coming away with that figure is not necessarily unreasonable. Would a figure of 100% be the acid test? Maybe it would. I don't think so, given the circumstances. And in practical terms, that is unlikely. That's the nature of negotiation. Otherwise, it would be called imposition. Also, we must recognise that those on the other side who have their views, passions and commitment to their communities, as well as their histories, have also been fraught with upheaval. So I think the idea that some of our partners in the European Union, some of those Eastern Bloc European countries who were under the yoke of the Soviet Union as colonisers, would take a different view, that they in turn are part of a group, a cabal, trying to impose, I'll finish on this, trying to impose a a colonialistic approach to another country. I don't accept that. I give way to the honourable member.
How else would the honourable member describe a scenario where a huge quota of laws are made in a foreign jurisdiction? How else would you classify that but colonialism?
We'll touch upon that a little bit later on. Well, can I just... I will give way, OK.
I thank my friend for giving way. I just wish I could understand, and maybe my colleague can help me out on this, because if on the one hand the European Union is a source of colonisation that has this disrespect towards the United Kingdom, to Northern Ireland, but on the other hand, as part of a trade agreement, we would simply trust each other to mutually enforce each other's rules without any level of oversight. At what point do we start trusting these colonisers as opposed to perhaps recognising that as part of an international trade treaty, we both have to stick to the same set of rules and see them upheld?
Thank you. My honourable friend does make a good point. At the end of the day, whether he likes it or not, whether I like it or not, and I do, they are allies in virtually the biggest, in fact, the largest trading area in the world. But I do accept that people have concerns. I'm not trying to deny that, and I'm not trying to demean them, and I'm not trying to push them under the carpet. Members do have concerns. And what I don't want to do either today is to revisit, if you want, the pre-referendum process. And I think it's unavailing at this stage to rehash or regurgitate the arguments, warnings, finger-pointing claims, the vilifications, the passions, the tensions that at times dominated the debate in the lead-up to and during the last weeks of the referendum campaign itself. But the situation we face is a direct result and consequence of that decision, and of that there's no doubt in my view. And I believe, just in a moment, I believe it's fair to say that often personalities rather than the policies dominated the discussions often and the debates at the time. And I also believe that at times the high politics, issues around sovereignty, self-determination and other factors came into play. However, such matters are rarely symmetrical. That's the nature of the democratic debate. And that's the nature of the democratic debate we have in this country, for better or for worse. I will give way to the honourable gentleman.
I'm grateful to the honourable gentleman. But does he accept that one of the consequences is that currently we have the United Kingdom, in part of which they have a second-class citizenship compared with the rest of the United Kingdom? And has he got any solutions other than the solution put forward by my honourable and learned friend in his brilliant bill? Because he brings intellectual rigour to try and address this intractable problem.
I think the fact that the honourable gentleman used the word intractable gives us a clue to how challenging it actually is. Look, when a country decides, Madam Deputy Speaker, for better or for worse, to withdraw from a treaty that has been a signatory to for over 50 years, there are bound to be issues that arise. Issues... I will do.
Thank you. Does my honourable friend agree with me that this bill undermines not only the UK's adherence to the Windsor Framework, but also the security architecture that the Belfast Agreement underpins? The Belfast Agreement is not just a peace settlement, but a cornerstone of our national security strategy, and by jeopardising our reputation as a trustworthy international partner, this bill weakens our ability to collaborate with allies on global security challenges. Would he not agree that by maintaining the integrity of the agreement that we are safeguarding for our national security and international standing?
I think that my honourable friend makes an excellent point, and we have to be very, very careful of the law of unintended consequences when you go down a particular path. Okay. So, issues which either no one thought about outside of a sort of an abstract environment, maybe didn't think would have significance, they subsequently became, or even at the time, were parked so we could come back to them at a later date. And we found that throughout that whole question post-referendum. Oven ready this, oven ready that. The reality is lots of things were parked and they are coming back to bite. And the problem with that element is that, as I indicated, the lot of unseen and ignored consequences are waiting around the corner and turns up like an uninvited and unwelcome guest in your house. Madam Deputy Speaker, please bear with me in relation to the potential unintended consequences coming out of a treaty. Imagine what would happen if we decided to, let's say, abrogate the North Atlantic Treaty, which of course no one would dream of doing, and we certainly know there would be huge consequences to undertaking such an action. And I suspect members would understand that there'd be pretty immediate and most probably predictable consequences to that. But it's sometimes the unpredictability of taking actions that come back to haunt us. And the same could be said for some other treaties which may appear to be of little significance and consequence in the short term, but might take on a whole new persona down the line. So, for example, I'm not sure that many people would initially grasp the consequences of, let's say, breaching the Antarctic Treaty. But there would be due consequences in course, and the idea that we abrogate a treaty or parts of a treaty, and then we could somehow revisit it, change domestic law, and then expect other countries to accept it would be unlikely. Can I just finish on this point, because it is important, and there are other treaties that we've got to look to, and I could go into detail in them, and I won't. But what about well, if members insist, how about the 1963 Nuclear Test Ban Treaty? What happens if we decided to tweak that a little bit through domestic law? What precisely, my honourable friend on the front bench says, dangerous, and it would be. What about the Outer Space Treaty? You know, the key provisions in that. What about the agreement establishing the European Bank for Reconstruction and Redevelopment? On it goes. I'll give way.
Isn't the Belfast Agreement an international treaty subject to international law, but it's okay to breach it when it comes to its provision of every key decision on a cross-community basis? That's okay, because that's only affecting unionists, I suppose.
The bottom line is, in my view, and the view of many other people, it hasn't been breached. Now, I completely accept that the honourable gentleman takes a different view, but I don't believe it's been breached, and I think better brains of a legal nature than mine agree with that. The Windsor Framework, we know, was in turn realigned through the safeguarding of the Union Paper of January 2024 that the honourable gentleman referred to, on the storm and break mechanism, and the provisions contained therein for Northern Ireland, the Assembly to approach the UK government in relation to the application of EU laws. And I looked at and read, as everybody in this chamber did, read the Windsor Framework, I suspect time and time and time again. I will.
I thank my honourable friend for giving way. North-South cooperation between institutions in Northern Ireland was a vital component of the Good Friday Agreement. So I thank him for bringing up this point about treaties, because this bill, and I have read the bill, in clause 14, makes it possible to disapply protections in the Windsor Framework for North-South cooperation. So I wonder if he could reflect on why disapplying the role of North-South cooperation would be consistent with the intent of upholding the Good Friday Agreement. That would be a relevant point for him maybe to reflect on.
That is a really good point, and I think it's important, and I think and I'm pleased we're having this debate. They're the very points that we need to carefully consider. We need to put them into when look at these issues and figure them out. And it's an excellent point, and I think we will all reflect on that. And I hope the honourable gentleman and gentlemen across the chamber reflect on that one. And it is important to note that the protection of the Belfast Agreement, it was paramount, and that was there to reassure the communities of Northern Ireland. And I hope that this debate today does continue, notwithstanding some of the points that the honourable member made, that people do understand that we are here to reassure as much as we possibly can. And I will. And I just want to make the point about the honourable gentleman. I know he will hold views that are born out of real belief in and commitment to his constituents and the wider communities across United Kingdom, Great Britain and Northern Ireland. And that is exactly the view that I take. I hold views born out of a real belief in commitment to my constituents, and every member in this chamber takes that approach. And who am I? Who am I to challenge their integrity on that particular matter? And I'm not in any way going to attempt that either from my side or cast aspersions on the other side. And I will give way.
Thank you, Madam Deputy Speaker. Thank the honourable gentleman for giving way. The honourable gentleman mentioned slightly further back there about the 3% laws that we have to obey on the EU. Would the honourable member like to see, in terms of medication for his constituency, where you can't get ADHD drugs for people who suffer, and diabetic drugs that we can't get in Northern Ireland? Would his constituency or his constituents like to see that? Would he like to have the situation where we can't get certain veterinary drugs that you can get in your constituency? And would the member also, wonder in his constituency, if he decided to, say you had a dog and you wanted to take it to the neighbouring constituency, you needed to get a passport to come back? Do you not think that's really unfair on us in Northern Ireland, as we're meant to be part of the United Kingdom?
I think the framework attempts to do that, and there is nothing, I suspect, as time goes by, for those issues to be teased out in a little bit more detail. But at the end of the day, we don't live, and I can say this, I don't live in a perfect world. I don't know about anybody else. My constituents, for example, have been unable to get access to drugs, and it's nothing to do with this issue. It's to do with a whole range of matters that have developed over the past 14 years in relation to government policy. But I don't want to go there. I don't want to. I'll come back to the honourable. I really don't want to go there. What I'm trying to get to, and I think members here today are trying to get to, is we're trying to do the best we possibly can given the circumstance we've inherited. Now, I know that might be cold comfort for some members across the chamber, but it is said with the best intent and with sincerity. It is not trying to brush this matter aside. It is a recognition that there are challenges. But I have to say, those challenges were bound to crop up, given some of the points I raised a little bit earlier on. Can I give way to the honourable member and then the other honourable?
And I thank the member for that point as well, and it looks like I'll not get to contribute, but I do want to put on record, Madam Deputy Speaker, that my party, the Ulster Unionist Party, actually campaigned to remain in the European Union because we actually thought it was best at that point, because we foresaw what is actually happening now. But we respect the referendum of this United Kingdom. But what we are now seeing is an enabling of what we were actually concerned about, by the lack of interest in this House in regards to some of the regulations that are actually coming through, in regards to how they are applied to Northern Ireland. And the member mentioned medicines. Yes, we have those supply issues, which are global supply issues, but we've also additional supply issues because of regulation from the European Union.
Well, look, as far as I'm aware, what this framework attempts to do is to tackle some of those particular issues, and I completely accept that the honourable member maybe doesn't accept that, maybe doesn't want to accept it. I don't know. I'm not casting aspersions at all on and I repeat this, the integrity or the beliefs of members. And at no time do I say anything that denies the right of people to hold the views that they hold, which are clearly, deeply and obviously felt. And I actually, in in a way, celebrate those differences. I give way back to the honourable gentleman.
Can I thank the honourable member very much for his contribution? But I want to give a constituent's point of view and ask the honourable member this question. And I quote her. This my constituent is a business. I currently supply materials to a lady in Devon who then produces goods for sale within the United Kingdom only. She is at a complete loss as to what to do regarding the GPSR rules coming in. The United Kingdom voted to leave, this is lady's words, voted to leave the EU. Successive parliaments have done what they can to make this nation as dysfunctional as possible and aid to its return to EU subjugation. Will the honourable member, what will the honourable member tell my business, my constituent's business, which must close as part of a price to pay to further the aim of an all-Ireland Irish Republic? That's what my constituent says, and that's very much contrary to what the honourable gentleman said.
That issue, as I understand it, that very issue is being negotiated. But the idea, but I understand what the honourable gentleman says, but I don't accept the other part of the point he made about subjugation. I don't think it's subjugation, and I want to come on to that. I understand what the honourable gentleman is saying, and I respect the point he made, and I respect the views of his constituents, as I respect the views of my constituents. But it doesn't alter the fact that the negotiation is taking place. And as I said before, and I'll repeat it again, these things are never, ever symmetrical. I will give way.
I know that he's tried, other members across the chamber have tried to make light of the use of the word subjugation and colonisation and everything else. But almost every week in this place, members complain if ministers do not come to this House and explain their policies and elucidate their policies and are prepared to be questioned in those policies, and quite rightly so. If ministers were able to do that continuously in this place, would members opposite not be claiming that we did not have accountable government, we did not have a government which respected democracy and which really was subjugating the people who were affected by those laws? I guarantee that no members here would accept that from ministers in this place, but yet accept it in Northern Ireland.
In this place, we are enabled to ask these questions in a whole variety of different ways. We do it in so many different ways. Oral questions, written questions, meetings with ministers. They are still available right across the piece. And the honourable gentleman knows that one. And in this place also, for the past number of years, I sometimes felt that I wasn't listened to by the other government. Now, that's what I believed. I was listened to by the honourable gentleman on the front bench often, and I completely accept there were honourable exceptions to that. But the issue at the end of the day is that we do live in a democracy where we can challenge time after time after time, and we have to be persistent with those challenges. And I just repeat, there are differences of opinion, but I do respect them, and I hope that this debate is being done in an as open and transparent way as possible. And this isn't the matter over. If this bill doesn't get through, the matter isn't over. Nobody's going to pretend that somehow we're all going to go our separate ways and no one's ever going to ask a question about it or challenge an issue through a minister in the future. This issue is going to come back time after time after time. And I know emotion has its place, but so too do hard facts, statistics and evidence. And they have to be balanced off against one another. But sometimes passion can lead to a febrile atmosphere, and that can sometimes dominate, and we have to guard against that. Yes.
I'm very grateful to my honourable friend giving way, and I think he's making a powerful speech, especially on the language that we use. And I said in my own maiden speech that when I agreed with a member from the other side, I would say so in this House, and I would actually call out the right honourable member for Richmond and Northampton, because I believe he did a good thing with the Windsor Framework, and after nearly 10 years of moving away from the European Union, he took a practical step which actually led to serious improvement. So I want to put that on the record, and I think that's important.
Absolutely. Look, as far as I'm concerned, this House debates the most challenging and sensitive matters often. And, for example, we saw that last Friday in the Chamber. An approach to such a sensitive, intensive debate based on conviction, not dogma, does really bring out the best in the House. And in that respect, that's why, Madam Deputy Speaker, and it's a pleasure to see you in the chair as well. I've been looking forward to this debate and to listening to the views of colleagues of all political persuasions, and I hope I have done that one. I think the fact is the Honourable Gentleman has given the Chamber the heads up in the light of the bill and the actions he's previously taken. For example, in the courts in relation to the relationship between a section of Article 6 of the Acts of Union, its putative incompatibility with the Belfast Agreement and it was in the Supreme Court, as far as I'm aware, was ruled out on all counts. And I'm sure members across the Chamber will recognise that engagement on this debate is done in good faith, and I repeat it time after time, even where there are differences of opinions. And I'd like to thank the Honourable Gentleman for the explanatory note he provided in relation to the debate, and as I read it with interest, particularly the text in relation to paragraph 11, in which he sets out the purpose of the bill, namely to provide ministers with the power to make changes to the operation of the framework in domestic law, restore the continuance of the cross-community imperative of the Belfast brackets Good Friday Agreement in respect of the continuance of the Windsor framework, and to safeguard democracy, peace and stability in Northern Ireland. Now, in my view, I believe that, in effect, is a reincarnation of the Northern Ireland Protocol Bill of 2022, which caused concerns in so many quarters, domains and jurisdictions. And the government at the time acknowledged that there would be non-performance of its international obligations out of necessity. And the government said it sought to reach a negotiated settlement with the European Union to forestall the need to invoke the concept of necessity. Now, it did withdraw the bill subsequently because it believed that it had secured the necessary conditions it sought as set out in the UK-EU withdrawal agreement, and therefore the assertion around the use of the question of necessity was never put to the test. And I, for one, am pleased it was not. If it had, in my view and the view of many other people, we were on the road to perdition. I think there's no doubt about that one. The bill, as I said, is another iteration of the bill that takes us back to June 2022 and puts the country once again in danger of breaching its obligations, notwithstanding what the Honourable Gentleman for North Antrim said, under international law. But the idea that the bill can invoke the concept of necessity for a reason to breach is beguiling, but it is illusory. I'll give way.
Does the Honourable Member not accept that the fundamental in international law jurisprudence in this area is the requirement that any such agreement must not infringe the territorial integrity of either state? And that patently has happened. So isn't that the fundamental flaw in the international law argument? It falls at the first prerequisite that you don't infringe the territorial integrity of the state with which you're making the agreement.
I mean, I don't want to go down that particular rabbit hole, but I will, in relation to that one, for example, say we have the sovereign base in agrarian Cyprus. We negotiated that. Is that a breach of their sovereign territory? Is that somehow wrong? We negotiated it, we agreed it, it exists, and it's used. Is that a breach? I don't believe it is, because it was negotiated. So one can, Madam Deputy Speaker, negotiate a whole range of things. This issue about some people indicate that an element of sovereignty is given away for a better or a more comprehensive capacity in another area. I will give way to the Honourable Gentleman.
So what the Honourable Member is saying is that if the United Kingdom decides that they will acquiesce, indeed support, the infringement of their own territorial integrity, then that's all right. Now, if that's the basis, then isn't that all the more reason why the government of that United Kingdom, a new government of that United Kingdom, needs to address that humiliating concession?
I don't think it's a humiliating concession at all. I think what it is, if it is a concession at all, is an attempt, given the circumstances we faced, to reach an agreement with trading partners in the light of the decision of the British people. We live in a world where we don't get everything that we want. We live in a world where it's a little bit of give and a little bit of take, and sometimes you're able to give more than you take, and vice versa. And as I said, I don't particularly want to go down that rabbit hole, because I don't think that's necessarily the subject of the debate today. We touch on it, and it's pertinent, but I don't think it should dominate the whole debate. Look, there's no doubt debating that the subject is fraught with all the concerns and anxieties and the consternation I referred to earlier on. And of course, we have to operate in that wider, if you want, political environment and milieu that countries have to do all the time. And I think it's only fair to highlight, I suspect, that the law of unintended consequences may decide to poke its head around the door and maybe even decide to walk through into this chamber, and there's nothing we can do. That is the law of unintended consequences. And that is the very nature of the issue facing us. There are no easy solutions. There are no easy answers to difficult questions. There are no off-the-cuff responses that will sort out the issue. By its very nature in this case, that is a statement of the obvious. I will.
Thank you, Deputy Speaker, as well. I appreciate the honourable gentleman giving way, and I very much like the image of the law of unintended consequences poking its head around the door, because one of the things that occurs to me during this debate is we need, in Northern Ireland and in Great Britain and the whole of our United Kingdom, we need to try and reduce the red tape that Brexit has introduced. And one of the most important things we could do is enter into a sanitary and phytosanitary agreement with the European Union. But to do that, doesn't the honourable gentleman think we will need them to trust us? That if we negotiate with them and we reach an agreement, we will stick by it. And isn't that therefore a challenge with this particular bill, that one of the laws of unintended consequences of it might be that the European Union simply will not do the discussion, the negotiation that we need to get these red tape reducing measures taken forward?
A perfectly valid point, and clearly the honourable gentleman has had a sneak preview of some of the points I'm going to raise later on, so I'll be taking that matter up with my staff in that regard. I think it's important to recognise in such situations, circumstances, that those views held by people are considered. And I'm sure they've been informed by many events and circumstances and by long-held political views, in addition to culturally held views that in turn have been informed by so many personal and political experience, some constructive and positive and others negative and traumatic. And I'm sure that, to give both credit and justice to the debate, honourable and right honourable members have attempted to bring, if not, I have to say, a fresh perspective to the debate, nonetheless a perspective that hopefully takes into account the perspectives of others right across the changer. And in this debate, I think the word irrelevant may itself become irrelevant, because the debate must face up to, in my belief, the position that many of the points being made are not irrelevant, taking into account the wide-ranging impact any change to the law would have both on internal and external relationships, both in the formal legal sense as well as the informal sense, which my honourable friend touched on. Madam Deputy Speaker, there are any number of points in relation to begin with in the context of the question of trust. The bill is asking the House to provide a legislative framework in which to abrogate our treaty obligations in effect under the withdrawal agreement, and that is aggravating and worrying. And having given it some thought, I decided to look at the landscape in relation to the issue of treaties, and I touched on it a little bit earlier, and the issue of necessity which has been raised in the past, which then sets off, I think, the justified claim from my side of the potential for abrogation. So I think that's a good place to go from here. And I say that because I think the ecosystem around treaties goes to the heart of the efficacy of partnerships, relationships, and, dare I use the word, trust between those who sign the treaty or the agreement or whatever it might be. Madam Deputy Speaker, given that, this issue does really genuinely go to the heart of trust and belief or faith in what we say as a nation. And I think I'd look to our finest playwright to set the scene, in fact, scene 4 from Shakespeare's Henry VI, Part 3. And for trust not him that hath once broken faith. And I think that concept, the concept of oaths and promises, was explored, for example, by William Kerrigan in his book Shakespeare's Promise. And he said, and I think it's important to say this because it goes to the heart as far as I'm concerned, and he said, it is impossible to imagine any kind of moral life without obligations, and impossible to imagine obligations without types of promises. We are always up against them. Before we ever reflect on what a promise is, we have made them and are expected to make more of them. We are born into nations that enter into treaties and agreements. Promises are with us like gravity. Man is a promising animal. And I think that... I will.
I thank my honourable friend for giving way, and I take him back to his point on abrogation of treaties, which is the modus operandi of the next incumbent United States President. And it is those behaviours that create instability in our international order, and yet those supporting this bill ask that we seek to disestablish an agreement which provides stability and seeks to address the intractable issues as raised earlier, and yet fix them with relationships with such persons.
Yes, it's a fair point. It's a fair point. But the question we have to ask ourselves is, if we agree with this bill today, and that's what we're being asked to do, are we in breach of faith, in breach of trust?
Absolutely.
And I think so. I believe we are. And I don't say that lightly or to be offensive or provocative. I will give way.
Thank you. Does the member think there's such a thing as breach of trust when it comes to relations within the United Kingdom? Are the citizens of this United Kingdom entitled to expect equal citizenship? Are they entitled to expect to be governed by laws they make in their own nation? Or are those secondary to tipping our cap to the EU? Is that the stance of the honourable member?
So my stance, Madam Deputy Speaker, is that if a person doesn't trust me within a democratic environment, they're perfectly entitled to go down to the ballot box and put an X against my opponent. And they're perfectly entitled to do it, and I respect them for doing that. That's the way we do it. That's the way we do it in this country, yes.
I think, Honourable White, many of us are passionate about equal rights. That is why we have concerns with this legislation. Now, the member opposite would not engage in the impact that this will have on human rights in Northern Ireland. And we all recall that your democratic rights are enshrined by this. When we talk about equal citizenship, it is about your ability to be represented. It is about your rights being upheld. And it is about a right of remedy. Does the member agree with me that a piece of legislation that rips up those rights in Northern Ireland by ripping up the Windsor Framework Article 2 would therefore deny rights to people in Northern Ireland that his and my constituents have, because we have recourse to the European Court of Human Rights if we feel that an overbearing government is breaching those rights. And so actually, if we're talking about equal citizenship within the Union, we must reject this legislation to uphold the rights of all.
Yes, and what I want to do, in this, my honourable friend's right, and what I want to do that is to reject it, and I want to reject it as respectfully as I possibly can, and I hope I've tried to do that today. Madam Deputy Speaker, countries have to operate with an international rules-based system. Indeed, that is the position that this country has taken on many occasions, even when the consequences for us have been dire. That is the foundation. The Honourable Member talked about foundations. That's the foundation that I don't want to undermine, that question of rules-based, trust, good faith. That's what I don't want to breach. I will.
I'll accept that trust within the United Kingdom is important. And the Belfast Agreement makes it quite clear. There's a promise made to the people of Northern Ireland that there will be no change of any sort in our constitutional position unless the people of Northern Ireland express a wish for that to be the case. And yet, the people of Northern Ireland have continually voted to be part of the Union. And does he, as a Unionist, I know he is a Unionist, and the Labour Party fought hard to maintain the Union when Scottish nationalists tried to break away. But does he not accept that he equally has an obligation to the Unionist people in Northern Ireland to stand by the promises that were made to them in an internationally agreed settlement?
My honourable friend to the side of me said that it strengthens the Union, and that's exactly the point that I would have made. I believe it actually strengthens the Union. I believe that some people don't accept that, but I do believe that it strengthens the Union. The thing is, like the Parsons egg, or is it a curate's egg, I don't know, there are good and bad parts of any treaty for both sides. Otherwise, we wouldn't need treaties or agreements because we'd all agree with each other on everything. And the reality is, dissonance comes with the territory.
Thank you, Madam Deputy Speaker, and I thank my honourable friend for giving way. The members opposite are talking a lot about cross-community support, and the member for North Antrim mentioned lack of consultation. Is my honourable friend aware of any cross-community consultation that's been done on this bill that we're considering today?
The honourable member may be in a much better position to me, but I suspect this is the place. We listen to the views of people, and we can reflect them in our observations today. I want to come to the issue about the continuing theme of trust. I mean, dictators and autocrats find treaties to be a sign of weakness, to be dispensed with as soon as practical. We tend in this country not to take that, what can I call it, a transactional and cynical approach to such matters, and I'm forever thankful of that. And keeping faith with a treaty or an agreement that we have signed without duress, without force, without coercion, says a good deal about our moral compass as a nation. So having started on the issue of the importance and the axiomatic state of treaties, I want to look at one or two examples out of the 14,000 treaties that this country is a signatory to. 14,000. Now, no, I won't go into the treaty issue again. But I would refer members to the Foreign and Commonwealth Office Treaties Online database if they should wish to look up the treaties this country has signed over the years. And yes, I do have a life. Now, this country's had a good deal of experience, it would be fair to say, Madam Deputy Speaker, in writing treaties, agreeing treaties, monitoring treaties, enforcing treaties and advising on treaties. And in this respect, there is the little that this country doesn't know about the history, implementation, negotiation, monitoring and abrogation of treaties. We may even be the place to go to get that advice. And this country, over the decades, has decided in good faith and with good intention to put its name, its credibility, its integrity up front by signing treaties to ensure that its national interests, as far as practically possible, can be secured. And we have before us centuries of experience of the pitfalls, implications and consequences of the potential unilateral breach of a treaty. And I ask colleagues to hold that thought in the deliberations and the sojourns through and around this bill. And it goes without saying that in reaching the terms of a treaty, serious, sometimes convoluted diplomatic manoeuvres and gymnastics are involved in that process. And that will come as no surprise to members at all. And it does, that's surprising to me. Madam Deputy Speaker, before a treaty is signed, I think it's fair to say you have to be careful before you sign it. But that doesn't mean to say one doesn't sign it. But once that agreement is signed, reached, ratified, then as far as I'm concerned, until the treaty is renegotiated through the proper channels, then it remains duly constituted. Do we really want to be in the position, and I quote again, that Sophocles suggested, namely, that no treaty is ever an impediment to a cheat? And I don't believe we're cheats. But he also said, all men make mistakes, but a good man yields when he knows his course is wrong and repairs the evil. The only crime is pride, and I hope that the honourable gentleman doesn't have too much pride. Call me old-fashioned, but I'm afraid that, whether we like it or not, we have to renegotiate a treaty through proper channels, or an agreement through proper channels. And yes, I will.
I thank him for giving way, and I am impressed with his knowledge of the classics. But he does make an important point, because it's almost as if we're being presented with a false choice today, ripping up the Windsor Agreement or setting it in stone. Whereas the reality is this agreement has already shown that it can adapt and evolve, and it will continue to do so.
Treaties are renegotiated all the time. The Honourable Gentleman makes an excellent point in that regard. And yes, it can be messy. And as I said, we've had a great deal of experience over the years about how messy it is. But that has never stopped us doing it and attempting to do it in good faith. The question, and I'll give way on this particular one, the question is, we have to ask ourselves again, whether the bill before us is a breach of a treaty or an agreement. That's the question I'll leave in the air whilst I let the Honourable Gentleman intervene.
Everyone in the House respects the Honourable Gentleman for his honesty and for the way he stood up for justice. And in any of the debates that I've been in Westminster Hall or in this chamber, the Honourable Gentleman epitomises what those who seek justice and honesty for people. However, in the Honourable Gentleman's contributions today in this House, the rights of the people of Northern Ireland, the rights of Unionists, the rights of all those who wish to have, through this bill, their rights restored, have not been spoken to or referred to. So I ask that Honourable Gentleman that I know to take that on board and speak up for the people of Northern Ireland, which quite clearly so far he has, unfortunately, has not done.
I regret that the Honourable Gentleman takes that view of what I'm saying. I don't think it's, I won't say it's not fair. I'm genuinely trying to be as conciliatory as I can, given the circumstances in relation to that question of trust. But the question is this a breach of an agreement or a treaty? And in my view, it is. And I don't think most people are denying that assertion. Now, there may be some people who do. And to be clear, as the House of Commons paper on the 4th of December indicated on page 18, no rule of a state's domestic law can be used to justify a breach of its existing international obligations. This is a principle set out in Article 27 of the Vienna Convention on the Law of Treaties. And I believe, I will do, but I genuinely believe that I'm bound by that one. And I can say, now we can caveat any breach of international law until the cows come home. It can be claimed that it is out of concept of necessity, as referred to before in international law, but we can claim whatever we want. It doesn't wash with other countries who we have negotiated with. And that, in a sense, is all there is to that particular thing. But I give way to the honourable gentleman.
Great. In pursuit of his filibuster, the honourable member tells us how adherent he is to international law. Why does he not adhere to the Declaration and the Principles of International Law from the United Nations of the 24th of October 1970, which says in very emphatic terms that there is a duty in treaties not to intervene in matters with the domestic jurisdiction of any state, and that the principles of international law require respect for territorial integrity. If those are the principles and the Windsor Framework infringes those principles, then isn't it the Windsor Framework that's flawed, not the Declaration of Fundamental Principles?
No, I disagree. I think that's predicated on a fallacy, if I'm being honest. And I don't want to use those words. I'm trying to be as temperate as I possibly can. But the honourable gentleman, I believe, is using that somewhat inappropriately. And as I said, we can caveat any breach of international law that we like, but it comes back to what do our partners, what do the people who are co-signatories to that think. But it's worthwhile exploring that concept a little more in detail, because it goes to the heart of our responsibilities as, and I use the word very thoughtfully, as a custodian, for that is what we are, a custodian of international law, not just in relation to a particular treaty, but in general terms. So the circumstance, I will.
And he's making a very powerful speech, and it's one that he and I have lived and breathed as people elected prior to 2024 and indeed prior to 2019, when the legislation that at the heart of this was constructed by this place was. Now, we were on the opposite benches at the time, and we all had to look at the concepts of international relations and what would happen because of the Brexit vote. So wasn't it striking that in the member proposing this legislation, he sort of talked as if that had never happened? We've been there before in all of this. There are no perfect solutions. That's part of the challenge that Brexit created for all of us. But in looking at what we do next, understanding that breaching international protocols has consequences is as important as thinking about what we do when we do breach those international protocols as we did with Brexit.
My honourable friend makes a really important and fair point. I think we have to be very careful in this area when we have international obligations. We have to be even more cautious when we're dealing with a situation that we found ourselves, given the context in relation to the Belfast Agreement. As I said, it's worthwhile, and I'm drawing to a close. Members will be pleased to know. It is worthwhile exploring a concept in a little more detail, because it does go on to as I said, to our position as a custodian. The circumstances in which we can depart from obligations are fairly clear. For instance, unsurprisingly, by mutual agreement or implied right to withdraw, and neither of those are the case in this situation. Maybe the honourable gentleman thinks it should be, but I don't believe it is. Can we say the treaty or the agreement is no longer in place due to agreed time limits or sunset clauses? Well, the answer to that question as well, or those questions, are no. And has the other side materially breached the treaty or the agreement, which in turn, then in turn, absolves us of our obligations? Well, I think not. I don't think that applies either. And what about the ability to carry out the agreement? Because I will do in a moment. Another rhetorical question. What about the ability to carry out the agreement because of the disappearance or destruction, quote, of an object crucial to the operation of the treaty? Now, that get-out clause doesn't exist either. Well, not that I'm aware, Madam Deputy Speaker. In fact, Madam Deputy Speaker, the Windsor framework is actually protected by the Vienna Convention on Treaties, that was brought out during the statement I referred to above. I'll give way to the honourable gentleman.
He mentions, has the other side ever broken the treaty? They did, of course. They did it in a fit of pique and rage and vengeance against the United Kingdom during the COVID crisis. They caught themselves on very quickly because they realised just exactly what they had done. But the fact of the matter is that in the mind of the EU, this treaty is not as sacrosanct as what the member is trying to make it in the case of the UK. We should not even think about breaking the Windsor Framework and the protocol. The EU, when it's convenient, have shown that they will.
Right. Look, I understand the position that the honourable gentleman comes to. Again, I disagree with the assertion that he makes. I disagree with the assertion that the honourable member makes. What I could say, just a moment. What I could say is that if the honourable gentleman wishes to call a Westminster Hall debate in relation to a whole series of breaches of treaties in relation to... No, I say this, Madam Deputy Speaker, because I know the honourable gentleman will be at the Westminster Hall debate, whoever calls it. So at the end of the day, if whoever wants to call a Westminster Hall debate to tease these out in a little bit more detail, in a little less of a fraught atmosphere, I'm more than happy to be there, either as the chair, possibly, or a participating member. Madam Deputy Speaker, I've just come to a close, but I will give way. You know, I have found this subject to be crucial to the wider constitutional and democratic process that we're all supportive of, and there are times when people are unhappy with decisions, and I suspect the honourable member is going to continue to be unhappy, so I'll let him speak.
It's not the fact that I'm unhappy, Madam Deputy Speaker, and I applaud the member in the way he's bringing the tone and tenure from the other side in the opposition to this legislation, because we do want to see a resolution for these things. But he talks about that breaking of agreements and when the trust is removed. And I go back to my earlier intervention in regards to the Belfast Agreement. When the Lord Trimble said that it demolishes the central premise by removing the assurance that democratic consent is needed to make any change to the status of Northern Ireland. So I just want to remind the member gently of that persuasion, because it also reminds me of the contribution the Lady Sylvia Herman made when she was in this place in regards to challenging the former Deputy Prime Minister in regards to the Belfast Agreement. When he started to talk about it, she simply asked him, had he read it? So I simply encourage any of the members on the other side of the House, before they quote the Belfast Agreement, to ensure that they've actually read it.
I'm grateful for the honourable gentleman's intervention, and I was going to quote from the Belfast Agreement in detail, but decided not to. I did read it, and I remember it at the time as well. So I implore the honourable gentleman not to push me on that particular matter. Look, there are times when I've been unhappy with the decisions made. I've been perplexed when, during the Parliament I've been party to, conventions and understandings that have been in operation for decades have been pushed aside for short-term political expedience. But it's one thing to go down the path in the operation of the workings of this House, for example. It's another to invoke that type of approach when dealing with agreements and treaties, especially when it's with trading partners and neighbours. I was, Madam Deputy Speaker, tempted to explore my contribution clause by clause in relation to the bill, all 25 of them, but I did resist. I did. It was just, it's just born out of discipline and willpower, Madam Deputy Speaker. However, I decided in that regard not to conflict with the patience of the Chair and honourable members on both sides. So I want to draw my contribution to a close and hope that honourable members across the House take what I've said in good faith and without any rancour whatsoever. Thank you, Madam Deputy.
Gavin Robinson.
Thank you very much, Madam Deputy Speaker, and can I, in hopefully the same tone, respond and say it's a pleasure to follow the honourable member for Bootle. I suspect there's a big prize for him waiting in the Government Whip's office after the conclusion of this debate. He welcomed every intervention going, and of course, in suggesting, and I don't besmirch his character, but in suggesting that there's an interest in the concerns that are being raised by the Unionist community. I do just want to reflect, Madam Deputy Speaker, that there's almost 2 hours left of a 5-hour debate, and I'm the third speaker. And there are scores of members from Northern Ireland on both sides of the chamber who will probably not get the opportunity to make their point, to represent their constituents, because of a quest to make sure that this is talked out. And so I say respectfully, the honourable member did exactly what he was asked to do. But in actual fact, when considering these issues, I'm not sure just how constructive that will prove to be. And say also that the honourable gentleman did say in his remarks that we'll be able to deal with issues as time goes by. Well, as time goes by, Madam Deputy Speaker, I've watched it. I've seen it on repeat, on UK Gold and in this chamber, when people say we will deal with these issues as time goes by. Well, here's an opportunity. Here's an opportunity to engage in the concerns that the honourable member for North Antrim has raised and has received support from across the Unionist spectrum in Northern Ireland to raise these issues. And yet, as time goes by, yet again, though it is said we shan't be dismissed, and though it is said we shall not be demeaned in the position that we're putting forward, that's exactly what is happening. Madam Deputy Speaker, I want to stand firstly, not only as leader of party and colleagues, but as a co-sponsor of the honourable member's bill this morning, and to commend the honourable member for the position that he has outlined to the chamber today and his success in coming out of the private member's ballot. He's not a gambler. Anyone that listens to him will know that he will put forward his principled position without fear or favour, but he took a chance and has this opportunity, and so I commend him for doing it, but doing it in a collective and cohesive way, in doing it in a way that has allowed for greater cooperation, not just from those in Northern Ireland, but from across the country. And I think he should be commended for that. He and I embarked on this journey as we approached the 2016 vote in the same position. And though over the intervening years I'd say there's been a few cross paths and there's been a few cross words and the odd cross sword, I suspect that it is good, it is fitting, and it is encouraging for people at home that we are speaking with one voice today on these issues. And I want to say to the Minister and to the honourable member who has spoken on the opposite benches so far, one of the best ways to deal with the issues that are being raised by the honourable member for North Antrim, by myself, and supported by colleagues in interventions and in their own remarks, it's to honour agreements that have been reached. When the honourable member said in his remarks that it seemed as if the people of Northern Ireland were being asked to suck it up, the Minister from a seated position, she'll not fall out with me for sharing this, said, no, we fight to maintain the Union. And she's agreeing with it now. But yet, whenever agreement was reached earlier this year in safeguarding the Union that outlined a number of stepping stones to a better place, the Honourable Lady, the Minister, and her colleagues who were present in the House voted in favour of that agreement. They voted in favour of it. They recognised the issues that were occurring in Northern Ireland. They recognised the harm it was causing to the people of Northern Ireland, to consumers with whatever constitutional outlook. If you don't share the principles in the Constitution, then recognise it's harming ordinary people in Northern Ireland. They voted for solutions on an interim basis, on a stepping stone approach to move these issues positively forward. Yet where are they today? Where are they today? What is the government's position on eradicating routine checks within the UK's internal market system? They supported it back in February. They voted for it here in this House back in February. And they did so because they recognised the constitutional implications it was having and the practical frustrations it was creating for consumers in Northern Ireland.
On practical...
So, yes, I will do Iain first.
I'm grateful. I just want to... He's on a really important part of what the purpose of the bill is today, for all the rhetorical issues, right down to hard tax. The reason why the government, the last government, went into the negotiations on Windsor was because it had dawned and become agreed by the European Union that the protocol wasn't working. Therefore, they recognise that nothing is fixed, that these things are about experience and then temper that experience and change. So when we've heard the comments from the other side that keep saying, well, you've reached an agreement and you will breach it, the real principle behind this is not. It's to recognise there are still fundamental flaws, and there is a better way, if we could agree it, that would harmonise everybody in that respect.
I agree with the right honourable gentleman, and I'm grateful that he is a co-sponsor of this bill and grateful for his presence here today. And he's right, because the same people that are saying this morning or in other debates that you cannot change what rests in a tablet of stone, it's the very same government that from 1998, who were part of securing the Belfast Agreement, worked in a political way with parties in Northern Ireland, including my own, to change that agreement time and again through processes, the Leeds Castle and St Andrews Agreement and the St Andrews Agreement Act. So the very arguments they are deploying today against change ignore the fact that they have a history of doing exactly the same thing, and on the Belfast Agreement particularly, something they often suggest is written in tablets of stone. I'll give way to my honourable friend for Chingford.
Can I thank my honourable friend for East Belfast and for what he's saying? One of those examples, Madam Deputy Speaker, is a small business, and the reliance applies through Etsy for their business. I'm going to quote them. It's important to have it on record. I simply can't continue without this supply. My suppliers have said they can't understand the system and can't afford to look into this any further. Therefore, I am cut off. I'm having to give notice to my landlord, Jim, that's his words to me. I was barely making ends meet at the minute as it was. Another business lost. This bill today has the opportunity to retrieve that business and every other business, and therefore see our economy in Northern Ireland thrive and create jobs. But government needs to do something.
Thank you, Madam Deputy Speaker. It's a fair point, and it illustrates the requirements to honour the agreement supported by the Minister and her Labour colleagues back in February to eliminate or eradicate routine checks within the UK internal market system. Does that deal with all the issues? No, it doesn't. Does that deal with what's in the red lane? No, it doesn't. Does it deal with the constitutional impurity of the overarching framework? No, it does not. But is it a step forward? Does it remove the frustration of constituents of mine and constituents of the honourable ladies for Belfast South who doesn't share the same constitutional outlook as me? Yes, it does, and it would, and it should have been delivered in October. So too, the honourable member has included in this legislation aspects on customs, aspects on parcels, another commitment made, supported by the Labour government back in February, to be implemented in October of this year. And they delayed it. And the Minister and members should know that we didn't get overly exercised by the delay because we recognise that it's going to be implemented by the end of financial year, but because of practicalities raised or attentions being diverted because of a general election and all the rest, it's not happening in October. It's happening, and it's a good thing. But it's also done in a way that recognises the overarching imposition that we have from the relationships that are totally unnecessary. If the honourable member for Strangford's constituent business, who is bringing products in from Etsy, thread, wool, felt, to make craft, I defy one member to stand up and indicate to me how that is going to have a material impact on the integrity of the single market. I defy one member to stand up and give me an example other than Lord of the Rings, where a tree has come from GB to NI and been planted and then got up and walked across the border. It doesn't happen. And yet we're told that for a tree to come from Stranraer to Belfast, it's going to destroy the phyto and sanitary integrity of the single market. It's a nonsense. And we are having to live with and try to work through the practical solutions to the overarching imposition that this Parliament, in spite of the concerns raised by people like me who were here during those Brexit years, as she was, and she wants to intervene, who raised them and were ignored. So when we stand in 2024 and say, why are we still talking about an issue that started in 2016, I'll tell you this. It's because members on both sides of this House did not listen to the warnings and the concerns and the opportunities for compromise and agreement, and moreover, in doing and repeating the same approach today, are storing up greater potential of frustration for the future. I won't give way to the Honourable Lady because I'm giving way to the Honourable Lady behind her.
And he actually knows that I have a lot of sympathy for his frustrations, because none of us should ever say there is a perfect solution out there to the challenges that he presents. That was always why many of us were concerned about the idea of Brexit, but we know that Brexit has happened. But once it happened, it created a series of problems. Does he recognise, though, there is more than one way to skin the proverbial cat that he's setting out, and that actually this legislation takes us back to those old arguments? What we could do, working together in this United Kingdom Parliament, is to look at, say, how do we get an SPS deal better? How do we deal with the problems that the border operating model has created so that actually all of our constituents can benefit? We can't go backwards. Brexit has happened. It's created all of these problems. Those who advocated for it may wish to reflect on that. But we can go forward in trying to tease out better solutions. They won't be perfect, but they could be better. This legislation isn't it, but I'll wage the hand of friendship across the chamber to find those better solutions if he's game.
I'm not going to respond to that last line, Madam Deputy Speaker. I'll leave it for others to determine. But listen, the Honourable Lady and I have engaged, sometimes helpfully and sometimes crossly, for years. For years. And I recognise that when there are opportunities to work together for practical benefit for my constituency or anybody else's in the United Kingdom, I will do it. But what I'm actually doing at the moment is sharing agreements that were reached and that she and her colleagues voted for, and yet we're still waiting for implementation. So let me give you another one. There was an agreement outlined in Safeguarding the Union that would require a labelling regime across the United Kingdom. And the reason for that was that there were no cost implications or benefits for businesses in Scotland, England or Wales to simply choose that they wouldn't supply our market in Northern Ireland. And we've heard every hue and cry from drinks manufacturers and food manufacturers across the United Kingdom who've said this is so costly. This is going to cost us difficulty. And yet Asda and Sainsbury and Tesco simply put it on their best before date line. Costs them nothing, Madam Deputy Speaker, but what does it ensure? No divergence of trade within our own country. What does it ensure? Access to the Northern Ireland market and the removal of a disincentive. But what have we heard? DEFRA have no interest in honouring the very aspect of the agreement that Labour supported back in February. And they're now suggesting that, yes, we'll take the power, but we'll not use it. Unless what, Madam Deputy Speaker? They are repudiating a commitment from an agreement that they supported. And yet they won't indicate what's the trigger point. At what point is it okay for them to step in? At what point should Northern Ireland be disenfranchised before our government, our sovereign government and our sovereign parliament will take steps to protect the consumer interests of the people of Northern Ireland? We don't know. We don't know. But what we do know is, whenever you are prepared to engage in discussions of a practical benefit for the people of Northern Ireland, resolving these issues, and Labour supported them, there has not been full and faithful implementation. Not governed by the Vienna Convention, but we're not seeing full and faithful implementation. I shall.
He has mentioned the fact that even when solutions are found, they're not implemented. We have had examples given that things which people never imagined would be problems become problems. And it's the fact of the matter this, that every time a solution is found, because we are subject to different laws in Northern Ireland than what there is in the United Kingdom, new problems arise. Correct. So unless we deal with the fundamental issue, what is it that causes the problems, then we're going to be continually looking for solutions, and we're going to continually then have to fight to get those solutions implemented, and that's not good for business in Northern Ireland, and it's not good for confidence in the Union.
My right honourable friend, Madam Deputy Speaker, is absolutely right. And what have we achieved over the last 5 years? A game, not a very enjoyable game, of whack-a-mole. It is as strategic as whack-a-mole. An issue comes up about VAT margin for second-hand car salesmen. We find a solution. Then another issue pops up, and another, whack-a-mole. That's the best strategic approach this government, the previous government, have for dealing with issues that are affecting us because of the decision taken back in 2019. I remember the parliamentary discourse around the quest to get agreement. But I know this. Whenever the last Prime Minister, Boris Johnson, engaging in this issue on the protocol, just let me finish and no need for your wee quips, went to the Wirral for a walkabout in a wedding venue with Leo Varadkar, and he fell smitten. He fell smitten for Leo, and he ditched the democratic consent principles that my honourable friend has referred to in Section 4 or 5 of the Northern Ireland Act. He ditched them. It was always part of the preceding arrangements that a consent vote in Northern Ireland would adhere to the consent principles within the Belfast Agreement. And Boris Johnson ditched them. In safeguarding the Union, a commitment to remove and repeal a legacy provision in the EU Withdrawal Act of 2018 at Section 10(1)(b) on having due regard to an all-island economy. A commitment that Labour supported, but now repudiate because it was in safeguarding the Union. Well, let me remind the House, it's only in safeguarding the Union because it actually features in the Windsor Framework. And a lot of the approach from the government benches are that we cannot achieve anything with the European Union unless we demonstrate our trust and our integrity or our servitude to the European Union. Windsor Framework, paragraph 53, indicates very clearly that there is no need to have a legal due regard to an all-island economy. That does not exist. Anyone that stands up here today and talks about their full-throated support for the Windsor Framework should read paragraph 53 and what it has to say on the all-island economy. It's a matter of fact that we don't have an all-island economy, that we have strands within our economy that operate on a cross-border basis, within the context of 2 legal jurisdictions, 2 tax jurisdictions, 2 currency jurisdictions, 2 VAT jurisdictions, 2 regulatory jurisdictions, unless covered under Annex 2 of the protocol. We don't have an all-island economy. It is a superfluous piece of legislation that is drawn out of the joint report from 2017, and it should go. And it should go because I say so. It should go because it was agreed under the Windsor Framework, something which is quickly forgotten and ignored. We've talked about Article 2 today. No one on these side of the benches is indicating that we should leave, through this argument, the European Convention of Human Rights, nor replace the Human Rights Act, which embeds those commitments within our domestic legislation. But the argument being raised on Article 2 of the Windsor Framework is that what has been presented as an international treaty, an agreement, a resolution on trade is impacting and frustrating the ability of this sovereign Parliament because of how the courts in Northern Ireland are interpreting the provisions on a whole myriad of areas outside trade. So immigration is a classic example, and the Honourable Lady from Walthamstow was right that we worked on this and we talked about this. But let's be very clear. Whenever I was standing up in this chamber on behalf of my colleagues as our spokesman on Home Affairs, and I was saying I will not vote for the Illegal Migration Act, it wasn't because I didn't think there was an issue with immigration. I do. It wasn't because I was ill-prepared to support government in their endeavours. I was. But because I was saying, and I said it in this chamber and my colleagues supported me, that though the government said the provisions would apply in Northern Ireland, we were indicating that they would not. And the very same people who told me that those immigration pieces of legislation would apply in Northern Ireland launched a leadership campaign on the back of the arguments I was making afterward. We were right. But it is wrong that a trading agreement should have any impact whatsoever on the ability of this sovereign Parliament to set a uniform immigration policy across the whole of the United Kingdom. It was wrong then, and I am glad that the Secretary of State on Wednesday night was indicating that that is a ground of appeal that the government are bringing forward, because it is wrong, and I hope if I agree to allow the Honourable Lady to intervene once more and once more only, she will agree that it is right to sort that issue too.
He's right. He and I may disagree about how to resolve it, though, which is what I want to ask him about, so I don't misunderstand what he's saying. Because what that disagreement was about the right to remedy being removed from people in Northern Ireland seeking asylum, i.e. the right to petition to an external court to uphold your rights. Now, this legislation, in what it does about removing the domestic legal effect of clauses of the Windsor Framework Article 2, breaches Article 4/1 and 2 of the UK-EU Withdrawal Agreement that requires individuals being able to rely directly on the provisions of that treaty for direct effect. What I want to ask him for is, does he therefore think it is right? Many of us believe there is a libertarian argument for a third-party court upholding your rights as a citizen, and those rights will be whether or not in a contract law in terms of what you are sold or your basic human rights. So is he saying his resolution is the right to petition a third party to protect yourself against the government should be removed from the people of Northern Ireland?
Our judiciary are independent from the government as well, she knows. And at first instance in the High Court in Northern Ireland, you can draw upon legal jurisprudence within the European system without needing to go to final arbitrary appeal in a third party, and she knows that. And she knows that. And yet I'd like, and the Honourable Lady and I will parse the course on many occasions, despite all the suggestions when challenged, that people are prepared to engage in this debate today or in this legislation or in the wider issues affecting Northern Ireland seriously and earnestly and with a willingness to resolve problems. There's been an awful lot of giggling dirties and Cyril sneers across the chamber. There's been an awful lot of dismissal of the concerns that aren't being raised today for the first time, but on many, many occasions. And it's not just immigration that has been encroached because of Article 2 of the Windsor Framework. Legacy. That was the basis on which the Secretary of State was raising this issue on Wednesday night. The legacy of our troubled past is an important issue. It has absolutely nothing to do with trade, nor trade within our own country. And yet here we have a case predicated on Article 2 of the Windsor Framework, frustrating this Parliament's ability to legislate on that issue. That can't be right. I'm just going to ask, is the Honourable Lady from Belfast South seeking an intervention, or is she just waving supportively?
I was agreeing with you that trade rules have nothing to do with the past, and I was hoping to remind the member that in fact The speaker before him, who tried to equate the murderous campaign of the IRA with the protocol, degrades everybody in this chamber, and it degrades every victim of that campaign. And I respect the member, and the member knows that, and I'm sure that he agrees with me, and I'm sure that he was as mortified as everybody I know hearing that intervention.
Madam Deputy Speaker, and look, I regard the honourable member as well. She knows too, and she's made that point now on 2 occasions, and free to do so. I want to come back to the SPS point that has been raised on a number of occasions. So here I stand, as a Unionist Member of Parliament from Northern Ireland, have engaged in these issues for the last 8 years. And my colleagues, whether it's recently in this place, but over exactly the same length of period of time, nobody sitting behind me has a shorter political career than I do. In fact, almost all have a much longer political career than I do. But we've engaged in these issues because we've been trying to find solutions that work for the people of Northern Ireland. Sometimes that causes discord amongst us. Sometimes the best tactical way of achieving that does not always meet unanimity or agreement. And when I'm sharing with you that when we get progress and we get achievements and we make progress and we want to see them implemented, there is no trust or honour earned when those agreements are breached or not fulfilled. But what we are invited to do is to wait for an SPS agreement. And I just want to be very clear. On a debate such as this today, on the Windsor Framework and on the EU Withdrawal Bill that the Honourable Member has presented, the Paymaster General should be here. The Paymaster General, who has been charged by the Prime Minister to engage with the European Union and resolve these issues, should be in this chamber. I greatly respect the Minister, but some of the issues being raised are for him. It is he who intends to go and secure this SPS agreement. Now, let me just say very clearly to members on the opposite benches who think that that is the answer to all of our problems. It is not. There is a world in which that process could provide solutions, get equilibrium across the United Kingdom on SPS issues alone. Nobody has yet said that that will see the removal of the overarching framework that is causing the imposition. Nobody has once suggested that once reached, all of the requirements, the legislative requirements and the impositions constitutionally and practically would dissolve. Nobody has suggested that. That's problematic. The fact that it is a single solution for SPS and doesn't touch on any of the other areas of law is problematic. But what's most fundamental? The Paymaster General knows as well as I do that the European Union don't see this process concluding within the next 2 or 3 years. Yeah. And I don't think it's appropriate or acceptable for the people of Northern Ireland to be waiting so long. The Paymaster General has not indicated what the content of his agreement should look like, nor has he indicated the content that he would like to achieve. I understand that this week, only this week, some 6 months into government, has he written to the devolved administrations asking for ideas as to what that process would look like. Only this week, 6 months in, to a key plank of the government's approach to resetting their relationship with the EU. That's simply not acceptable. I'll give way to all of you.
Thank you, Madam Deputy Speaker. I've been listening carefully to the Honourable Member, and I came here today because of the harm that the botched Brexit deal has done to my communities and my fear for what this bill would do to those communities and the economies in the very centre of London. So, as I was just listening carefully to that point about the frustration about the delays with implementing some of the solutions that you think could make, that the Honourable Member believes could make a difference, What I'm confused about is why the Honourable Member and those supporting this bill think that going back so many years, which is what this legislation is proposing, would actually help to make progress on the many issues that I think we all, even on these benches, still believe need to be fixed. And so will the Honourable Member who is supporting this bill explain to us why going back might help us to move forward on some of the areas where we think there needs to be some progress?
Well, to the Honourable Lady, I was happy to take her intervention, just not in the middle of the point I was making. But this bill does not take us back. If we are interested in building trust and a reset with the European Union, why is it not conceivable that we could get to the place where we would respect one another, acknowledge one another's purity of legal services and legal systems, and the importance of the rule of law, and the ability to mutually enforce standards with one another? Why is that so inconceivable? Why is it possible for the European Union to outline a system that allows goods to move from the Republic of Ireland through Northern Ireland without any border checks and into GB, but not the other way around? Why? Would anyone stand back and just ask themselves the question, is all of this, with the attendant hassle and constitutional impairment, necessary or worth it? It can't be sustained, not practically or pragmatically. The impositions are not required. We started this journey in a place of equilibrium on standards. When we left the European Union, our standards with the European Union were exactly the same. Mutual enforcement wasn't mythical then, and it's not magical now. There's no reason why I cannot conceive a solution based on a reset of relations if necessary and trust built up, that mutual enforcement would not be the better answer.
The member give way?
Certainly.
Thank the honourable member for giving way. Just on the issue of trying to build and a possible reset, would he agree with me if as seems almost inevitable now that this bill is going to be talked out, given the attitude of members opposite, but if that is the case, the Prime Minister has indicated that he is going to speak with representatives of Northern Ireland and the Republic of Ireland in the next few days. Surely there is an opportunity, if it is the case that the Labour Party in government are saying, yes, there is an opportunity to make progress, yes, there are difficulties to be resolved, there is the opportunity for the Prime Minister within a few days to tell us exactly what he's going to do if they don't support this bill.
Thank you, Madam Deputy Speaker. Look, I agree with my honourable friend wholeheartedly. I want to give the honourable lady who intervened a moment ago just another example, because you will have heard colleagues earlier in interventions, you will have heard the honourable member for South Antrim in Prime Minister's questions, you will have heard me in Northern Ireland questions raise this issue around the General Safety Product Regulations coming into force next Friday. What's the best answer we could get from the Secretary of State of Northern Ireland? We're in discussions. What do we hear from members opposite? It's in train. Information should have been given to businesses long before next Friday. Long before next Friday. But have I ever once heard anyone on the other benches say, actually, the Conservative government in January 24 extended an agreement from February 23 to adhere to the EU safety markings, to adhere to the requirements and standards under the EU safety markings with CE markings on goods, on general product safety? Why are we in a situation when our government, the last government, but our government, agreed to adhere to the standards of the EU on general product safety, and then find that come next Friday it's all going to be too problematic for GB businesses to trade with a part of the United Kingdom? It is wrong. It should not be the case. And yet talking today about the aspiration of having a solution when this comes in on Friday, and businesses should already have the information, really is not satisfactory at all. I will.
And does he not find it even stranger that when it comes to products moving from the Republic of Ireland into GB, the government actually rushes to find an accommodation? And only last week,
And the Minister was telling us that she was totally satisfied that away from the border checks would be perfectly suitable because producers in the Republic of Ireland were getting concerned about access to the GB market, and yet our government can't find any urgency to ensure that products coming from GB into Northern Ireland can be facilitated.
Thank you, Madam Deputy Speaker. My right honourable friend is right, and that's where this becomes just so thoroughly obnoxious for people in Northern Ireland who stand back and say, well, whatever about your constitutional view, or whatever about Labour's position on this, or Conservatives on that, why? Why am I being impinged upon? Why am I being treated differently? If a workaround is available for the Republic of Ireland to get into the GB market, why not so for me? And whenever we talk about market access, we talk about the UK internal market system, we're talking about a marketplace in principle as somewhere where you can both buy and sell, trade flows in both directions. And yet all too often when people on the government's benches talk about market access, Madam Deputy Speaker, they only consider it in one direction without considering the implications that that has for businesses in Northern Ireland. I want to conclude with one final point about the democratic scrutiny mechanism and the vote which is due on Tuesday. It is a complete inversion of the commitments given in the Belfast Agreement. It was brought forward, as I said, following Boris Johnson's bedazzlement with Leo Varadkar in the world. The protections that were offered to people of Northern Ireland were stripped away in the haste of that political union. And it's left us in a position that even though cross-community support will not be attained for the continuance of Articles 5 to 10 of the Windsor Framework, that will continue. And there is a strong argument, and others have made it, that we should not countenance giving credence to that process with our presence. But as I said in September in our conference, our party conference, and I've said since, we will be there on Tuesday. If the vote proceeds, we will vote against the continued application of the Windsor Framework. We do so in the knowledge that when we stand forward and we demonstrate our opposition, we do not leave it to chance that anybody on the opposition benches or in the European Union would ever credibly try to make the argument they weren't even interested to vote. They didn't turn up. We will demonstrate by our vote and our voice our opposition to the continued application. Sorry.
I thank the Honourable Member for giving way, and I want to initially commend the Honourable Member from North Antrim for this bill. It's disappointing that I won't get to speak, and I trust the Chair will give a little bit of leniency, and I've deliberately not jumped up and down in each of the speech. Would my Honourable friend agree with me in summarising his remarks that there are those in this House who underestimate the damage caused by these current arrangements at their peril? Unionism is reeling at the fact that their mother Parliament has and continues to sacrifice Northern Ireland on the altar of political expediency. Unionism has had enough. Businesses and consumers have had enough. When they can't, for example, get plants, seeds, trees from GB, they can't bring in farm machinery just because it may have British soil on its wheels. They can't bring seed potatoes from Scotland. All traditions in Northern Ireland.
The Honourable Lady has made her point. Gavin Robinson.
Thank you, Madam Deputy Speaker, and I just want to acknowledge the Honourable Lady and the position that she's outlined in her contribution. I wish it was not so, that so few members will get to contribute. Indeed, I had arranged that it was going to be my right honourable friend from East Antrim that would lead for us, and he decided that I should do that for him, because I want to make sure that people get the opportunity to contribute. But just as we'll make our point today, we will make it on Tuesday, and I would encourage other Unionists to vote along with us. It will trigger the review that I think will be important, and I hope won't be dismissed in the same way that the concerns being raised today or in the past are being dismissed by members here. That review is there to take evidence and take information and try to suggest how these arrangements may change. but another downfall of the government's inability to honour the commitments that they entered into back in January, February. The purpose of Intertrade UK, the purpose of the independent monitoring panel, was that there was an evidence base to draw upon when this review is triggered. And yet their own reluctance, their own lethargy, means that that information will not be available. That's a shame. A complete shame on the work that was put in to make sure that we could have these discussions in a robust and an evidence-based and an honourable way, that that information just simply will not be available, Madam Deputy Speaker. And though I want to wish the Honourable Member for North Antrim well with this bill, and he knows the frailties of the private member's bill process, and we don't know where this bill will end up. But the issues raised, the principles engaged, and the imperative to keep working at it properly to the benefit of the people of Northern Ireland within our United Kingdom will not be diminished today, and it will not go away.
Claire Hanna.
Thank you very much, Madam Deputy Speaker. I don't intend to speak long either, so that others can get in, but primarily because we have spoken about this morning and noon and night for a lot of the last 8 years, and because Northern Ireland in general wants to move on, and I think people at home's hearts are sinking at the prospect of going back in time like a demented moth towards the hard Brexit flame and reopening a time that was so destructive to our public services and to our economy, when our economy, our jobs, our crumbling health service were put on the back burner while we indulged years of discussion about sausages, about smoky bacon crisps, and the menacing rallies that accompanied those discussions and the holding down of the Northern Ireland Assembly. People who I represent don't recognise the Mad Max scenario that the members continue to paint about a lack of availability of food and of products on our shelves. It's not the reality that people are living in. I don't want to relitigate all that happened since 2016, but it is fair to say that Brexit sharpened all of the lines that the Good Friday Agreement was designed to soften around identity and sovereignty and borders. And it is a fact that hasn't really been mentioned. I'm not a majoritarian person, but Northern Ireland very clearly rejected Brexit in 2016, and in the 8 subsequent elections, in increasing numbers, have supported parties and candidates who have sought to put mitigations in place. It is also a fact that I and my party will stand over every decision we took in those years. At the times in this chamber, in the other chamber and in the media, we begged the members opposite not to make this a winner-take-all scenario, not to follow Boris Johnson down yet another blind alley, not to take the assurances that they were being given. And at that time, there was not a whisper about consent or consensus or cross-community affairs in all of those times. So, of course, many of the people that I deal with, they see implementation difficulties. Brexit was entirely a project about trade friction, and it has created friction for many people, including small businesses, and the people I represent want to address those things. They absolutely do. They want to streamline the processes, and they want to use the framework provided to solve problems, but they don't want to tear down the edifice of the solutions as this bill would do. In fact, last week, the Assembly, as the members opposite will know, endorsed my party's proposal to move forward, not to rejoin the European Union, not to cancel Brexit, not to reopen all of those wounds, but to look to the future, to try to increase our voice in that decision making, to try and grab every single economic opportunity that comes our way, east and west and north and south, because my party and the people who oppose Brexit have never tried to make people choose between trade or possibility in either direction. We simply believe that we've been handed some lemons by Brexit, but we're ready to make lemonade. And the opening speech, and I will give way in a moment, the opening speech at length by the member will do nothing to allay the fears of many of my constituents that really, at the heart of this, it is about repudiating rights, and it is about hardening the movement of people and goods north and south. And I think that feels to many people, including bringing in the legacy of the past, it feels to many people that that's what the member is attempting to do. I'm happy to give way.
It appears the member hasn't been listening. The whole focus of my speech was how we give back rights to the people of Northern Ireland, and the whole focus was how we sort out our trade across the border, not the opposite. But the honourable member has a rich heritage in terms of advocating for cross-community issues. I have two questions, if she would address them. Does she think the decision on Tuesday in the Assembly is a key decision, in that the Assembly will say for the next 4 years we're prepared to accept whatever laws we don't even know about yet, whatever they are from Brussels, we're prepared to accept them. Does she think that's a key decision? And if it's a key decision, why should it not be on a cross-community basis?
And of course I was listening, because I do listen, and as the member said, I try to find consensus, but people were forced to listen because for whatever reason large parts of the media have indulged this for many years, and the member knows he has had an outsized platform in the media, and we have listened and we have tried to resolve. As I stated very clearly numerous times in the last 8 years and in the last few minutes, unfortunately, there was no consent sought or given for Brexit. That wasn't a decision that was afforded the luxury of being cross-community. So therefore, protecting the mitigations has to be taken on a majority vote as well. All that is left for us to do, and as I say, everybody wants to solve the problems, but I don't actually hear any solutions coming forward. We get more of the magical sovereignty dust and the Henry VIII powers, and some future minister will come up with some future solution that didn't appear in the last 8 years. It's about solving problems, Jim. That's what people elect us to do. The constituents elect us, I'll tell the member for North Antrim, not to just mine grievance, not to use the protocol as a receptacle for every bit of frustration about progress and the modern world, but to solve the problems that are before them. And that's all that's left for us to do, calmly, as leaders and as neighbours, to work through the challenges, yes, streamline the processes, find workarounds, and to accept the honour of compromise. That we got Brexit, that a lot of us didn't want it, but we're also getting the protections to help mitigate it and to reconcile it with our politics and our geography. And I said it earlier, and I'll say it again, hundreds of thousands of us constitutionally compromise every day because we're Democrats and because we accept the principle of consent and because we accept the framework that most people in Northern Ireland want. The fact that the member is opposite, and I have to say there was, if not rejoicing, certainly respect for the fact that the Democratic Unionist Party appeared to accept that in February when they brought back the Assembly and agreed to work through these solutions. But it continues to rankle with people that it's expected that constitutional compromise is expected for those of us who aren't Unionists but won't be tolerated by those who are. Let's move forward. That's what the people have consistently asked us to do in eight elections. That's what the Assembly asked us to do last week. Let's grab the opportunities. Yes, dual market access isn't perfect, but we know from businesses time and again the first thing they want from us is stability. I'm begging the members opposite to do that. Don't tear down the structures that it's taken 8 years for us to create. I don't believe the electorate will forgive you if you do that.
Him. So Iain Duncan Smith.
Mr Deputy, thank you very much indeed. I'm going to try and be as brief as possible to allow others to come in, and I want to come back to the issues around what this bill is actually about, not what people say it's about. First of all, I want to dispel the idea that this is going backwards. This idea of mutual enforcement was in fact originated, as has been made by the others who have been speaking, in the EU itself at the time, by those who were tasked as very senior officials, British and others, to come forward with a solution prior to the end of the Brexit debates, etc., with an alternative way of making the borders work and taking the heat out of some of what was, as we see later on, became really quite powerful and ended up with a government literally unable to move any motion at all and get it succeeded in that period. And I also say I have a personal experience of this, because I went, when there was a break in the negotiations between the UK government, who at the time I think handled that pretty badly, by the way, but that's notwithstanding, and with the Commission, I managed somehow to get a team of people together to go and see Monsieur Barnier directly. And we sat at a table with all of his negotiators and a few of ours that were there, and we talked through the principles. Now, this is before it became a concept of mutual enforcement, but we talked about what already existed in the EU with others from outside the EU and inside the EU and how they traded. And we ended up reaching very much the same conclusion as was reached originally by that group of people, Sir Jonathan Fall and the others, where this was the better deal. Now, what he agreed with us, very principally, he said at the end of that agreement, and I can see him literally now, following me out as I put my coat on, he said, the principle behind any chance of this being agreed is that we must have trust. He said, without trust, we cannot have an agreement. Now, the sad part about that, when I came back to the UK to speak to my government, was that they didn't want to take any interest in that as a departure. They had already got bogged down in other areas, and then sadly 2 weeks later what actually happened was the government went back in and carried on with their complicated and I thought hopeless negotiation without setting the principle about what they wanted first. And I think he was open to that, and I think they wanted this. At this stage there was no question about weaponising the border. It was how do we reach an agreement. And we could have done much more then, and I still today think this is it. So this is not going backwards in the sense that it destroys what we've done. It actually says what we've done so far in 2 stages. The protocol was always, it seems to me, could only have ever been temporary. And the Windsor Agreement, which I didn't support, opened up the negotiation again, which was good, but the ask was so limited and in some ways rather restrictive that what we've ended up with is the principle is there, but the practical bit of it doesn't work. And the answer is because that is the moment when we should have used the opportunity to go back into mutual enforcement. And what is so wrong about that? Why, the EU already uses these principles when it has deals with other countries. I said earlier on in the intervention, the classic one is New Zealand, where they trust the New Zealand veterinary offices, particular key ones, but they trust them all once they're registered, to be able to say whether or not certain foodstuffs under SPS rules are packaged properly and are agreeable under the EU rules, that they meet EU rules. It's a critical component. And so when they're shipped at Rotterdam, where they most often arrive, comes up on the computer and they wave them through. Any checks that have to take place in Rotterdam for non-EU countries take place 30 kilometres behind the border, and they are spot checks, just in case something has happened en route or something else has changed in the way. In other words, it moves smoothly through. But those arrangements were not really agreed here in the various agreements that we reached. And eventually, trying to draft this together, I and others sat down to try and figure out how could we make mutual enforcement work. And so this bill, and I give credit to the honourable member for having brought this through of Antrim, because it does give us a chance to debate it. The sad part is, listen, I know very well what goes on in this chamber. I know only too well how Fridays work. If the government doesn't want to have any further debate on something, they arrange for it to be talked out. It's happened on both sides. You know, cynicism exists on all sides of it. I understand that, and so lots of people will have come in, particularly from London, because they're closer, and they will do what they have to do to make sure they talk this out. So this is not going to get through. I never expected to get through. Honestly, don't go for objections. You know very well that's exactly what happens. Some will be here because they believe in some things, and I look across my neighbour, and I know that, but the majority are not. And the point here about this is that, therefore, let us just understand fundamentally what we could have been discussing and what would, for the present government now, to engage in and to talk to the EU about changing these arrangements. The problem is the arrangements are damaging relationships and issues around Northern Ireland. We know that. No one's arguing that that's not the case. And the question, therefore, if you have problems like that that affect the Constitution and affect the smooth running of businesses, both in Northern Ireland and in the wider United Kingdom, then surely any government would want to make sure those are settled. It's not a polemic. It's not a right or a left-wing thing to do. It's called practical governance to try and figure out how this works. Now, I didn't agree with my government when they brought forward the Windsor Agreement in its final agreement, and I say that I voted against it. And I voted against it because I thought they had lost a real opportunity. The EU had accepted that their imposition earlier on doesn't work, and so they had to change it. But what we ended up with was a kind of de minimis change which didn't solve the problems. In fact, some of them have got worse. So the key components of this, stripping out all the politics of it, is that mutual enforcement entails each side to make reciprocal legal commitments to each other to enforce the rules of the other with respect to trade across the border. In other words, that we would accept that where our exporters export into the EU, that we are responsible if they breach those EU regulations. So if the EU says these individuals, this company, is exporting goods that are in breach of the terms of our trade, the UK government takes the responsibility to proceed against them themselves, and vice versa with the EU. That requires, therefore, by the way, not no border, because there's always been a border in Northern Ireland. We don't want a hard border. That was always the issue. People talk about border, they mean hard border. You know, I had some experience of that when I had to man one of the checkpoints there when I was sent to Northern Ireland. I hated doing it, but that's a hard border. We don't want a hard border, and this obviates the need for a hard border. Borders will exist, and we've talked about that in terms of currency and VAT. I'll give it very quickly, but I did promise I'd be quick.
Just on the concept of avoiding this mythical hard border, would he agree with me that any land border of 300 miles with 280 crossing points would leave it impossible to implement such a thing? And really the process that we're embarked upon is trying to get a two-way flow of trade that obviates the need for any of those checks anywhere in the world.
Indeed, that is the case. And the real point it would get rid of is the RC checks, which are an anathema that one part of the United Kingdom is now treated separately from the rest of the UK. Surely that's a reasonable idea, and if it exists in this, then shouldn't the government want to take this through to the next level and to debate it? Because this is what it does. Mutual enforcement does not of itself remove customs duties, nor does it remove, harmonise or require mutual recognition of standards. It works by inverting the usual approach to customs enforcement. Duties may be, for example, imposed for anti-dumping reasons or due to subsidies that one party claims are injurious to itself or to companies as a result of goods failing to qualify for zero duty under rules of origin. This is what it does. All the rest that's been talked about is not what's in this bill. It's very simple and very practical. And the TCA between the UK and the EU already has an agreed mechanism, which is very important, for identifying and addressing these distortions. So surely if we're able to allow that to be the case and change it, that's how it works. And there are other areas too, and I'll speed through these as quick as I can. Mutual enforcement can also, under these terms, accommodate the collection of customs duties. Well, the detailed procedures are beyond the scope, obviously, of a paper like this, but they are for the bill. The reality is an approach is the creation of a system whereby an order of goods from the UK to the Republic of Ireland triggers a UK export declaration and an EU import declaration, such that EU's customs duties, if owed, are put into the goods invoice and paid by the importer to the exporter. There are many other ways that are facilitated by this, and particularly now, as almost all of this is done using modern technology, not large sheafs of paper, and a man standing at the border with a ladle to check whether the brandy that you're importing or exporting tastes like brandy. That doesn't happen anymore, but some of the debates around this would seem somehow that we haven't moved on from the 17th century in terms of customs requirements. It works. And the other bit that I would say, Deputy Speaker, is to ensure compliance with this regime. A penalty, therefore, in this arrangement would apply to those parties who fail to follow the procedure. The penalty would apply to exporters and hauliers, therefore incentivising all parties involved in the carriage of goods to ensure that appropriate EU customs duties are therefore paid. The same would be, by the way, required for the Republic for its importers. It should be noted, and this is the important point that's gone missing, that An analogous system would, in any event, be required for the red and green lane approach prescribed in the Windsor framework. Is this going back? No, it's using what we've got and making it ultimately better. And that seems to me the practical principle behind this idea of mutual enforcement. We should have started at this place, but we have an opportunity now to look at this and decide there is a better way to do this that will take some of the good stuff that's already there and improve it by saying to the EU, and many of them agree this, by the way, already had further discussions, that actually what we want is a smooth process between the EU and the UK, because everything else then requires. Somebody got up, I can't remember who it was, and said, did we not think they were allies? Did we not think they were friends? It's because we think they are allies and friends we want to get rid of the things that make us have rows and arguments about the most practical issues that could be dealt with. That's the point of what this mutual enforcement process is all about. Get rid of those ludicrous arguments about who we are and who they are, and we can be very good allies and friends, which they are, and we will need to be over the next few years as we enter, I think, arguably the most dangerous time that I can remember. And finally, I simply want to say the EU could, and arguably should, and here's a point for the government, given that almost identical rules apply in the UK and the EU, negotiate an SPS equivalence agreements with the UK as it has done for countries, as I've made before, as far away as Canada and New Zealand. It doesn't take a... Okay, I will.
Given the Right Honourable Member's experience of international affairs, what does he think are the prospects of the present arrangements, whether they are an incentive or a disincentive to securing a trade deal with the United States of America, given the present arrangements?
I thought he might tempt me down that road. Can I just say, first of all, whether we have a trade deal with the United States of America or not is way beyond my pay grade. No government that I could ever join would ever have me, so on that basis I will answer it from my own perspective. I simply say, yes, there is a change in the administration in America. I do understand one thing, because I did actually negotiate a trade deal with the incoming president of the United States. I've never quite told the full story of that. But it became very clear to me in those discussions that he wanted a trade deal more than anything else with the United Kingdom, and he said so. How you go about that is a complicated issue, but there is an easy way to do it. That's called sector-by-sector trade arrangements, which you agree and then move on to the next area. But I do simply say it is made more difficult by the arrangement that somehow part of the United Kingdom now seems to be parked inside the EU, which makes it difficult for them to understand whether or not these would slip through in any goods, etc., into the EU. That will cause a problem. Whether it's insurmountable is not mine to say, but I do say that these are unnecessary difficulties. But if we had mutual enforcement, that would not be the case. It would be very clear at that point that that is actually a very good basis for a trade deal, by the way, with the United States to smooth our arrangements with them. Our biggest trading partner, and actually, ironically, unlike with the EU, one that we have a surplus with, not a deficit of some significant degree. But I want to end on this very simply. I know in terms of what's happened over the last 30 or 40 years, there are big, deep gulfs and divides over anything that touches on Northern Ireland and its relationships with the UK and also with the rest of Ireland. And I have to say that I want to I came here to look at the practicalities of a better way, a way to sort out the trading relationships that leaves the Northern Ireland a solid part of the United Kingdom. Yes, it has a special place because it's the one land border that we have with the EU, but that doesn't mean to say that we should treat it differently in terms of how its arrangements are with us here in Parliament. And my worry is that we set those insurmountable problems ahead first, at the end of it, we then do nothing. We could do this. If the government had its way, it would take all of the bits from this agreement and it would try and implement those and discuss those with the EU. The EU knows it doesn't work. It's time to make some changes, and I simply say just talking this out helps nobody.
Costigan. Thank you, Madam Deputy Speaker, for allowing me to speak in this debate today, and thank you to the member for North Antrim for bringing this debate forward. I listened with interest to some of the points made by the honourable members opposite, and was interested in particular in the words from the honourable member for Belfast East, who suggested, and indeed the honourable member for Chingford and Woodford Green, who suggested that there are attempts to talk this bill out. I would say to the honourable members opposite, the only people who appear to be attempting to talk this bill out are the honourable members for Belfast East and North Antrim, who have done a very good job of it. And I think it's become more and more clear in this debate today that, in fact, there is no interest in bringing this bill forward from the member for North Antrim. He knows that this bill is unworkable. He has no intention of it ever becoming law. And what he is doing today is purely and simply political posturing for naked electoral reasons. I also was interested and slightly amused to hear from the honourable member of from North Antrim refer to his interest in ensuring equality and equal access to citizenship for all of the citizens of Northern Ireland. And I wonder if he felt the same way about extending access to equality and citizenship when it came to reproductive rights for the women of Northern Ireland and when it came for the right to equal marriage for people in Northern Ireland. I don't recall him being as vociferous at that time. So it has been an interesting debate, as I say, but I was also interested in hearing the member from South Antrim. Apologies, I do represent an area very close to Acton, and my honourable friend knows that. The honourable member for South Antrim, who asked if we on this side had read the Good Friday Agreement. And indeed, back in 1998, as a very young woman, I recall vividly buying the newspaper that printed the full Good Friday Agreement and laying it out on the floor in my bedroom at the time and reading through it clause by clause. Because for me and for the people of Northern Ireland, for the Republic of Ireland and for all of the United Kingdom, it was such an important and joyous occasion to see that agreement come to fruition. And that's a joy that I think is really only properly experienced if one again watches Derry Girls, the final episode, when Orla dances through the streets of Derry on her way to register to vote in favour of peace in Northern Ireland. And what a contrast that moment of joy is, Madam Deputy Speaker, to some of the words we've heard from the honourable members opposite today, which have been less about forging a prosperous future for Northern Ireland and more about raking up the arguments of the past. We found ourselves today revisiting old grievances rather than pushing for progress. This bill drags us back into the quagmire of disputes that were settled through the Good Friday Agreement and the Windsor Framework, a framework painstakingly negotiated and endorsed as a solution that works for Northern Ireland and for the United Kingdom. And I'm afraid the members had sufficient time, I think, to speak today. This bill is an attempt to undermine, I'm afraid, the foundations and the very underpinnings of the Good Friday Agreement, and it risks creating far more issues than it claims to solve. Now, given the honourable member for North Antrim's electoral pact with Reform UK, I would have thought he was happy to get Brexit done. Yet here we are renegotiating 2019, stuck in an endless Groundhog Day of Brexit debates. While the honourable member looks backwards, this government is looking forwards to a stable, prosperous and peaceful Northern Ireland. Madam Deputy Speaker, let me look first at the most fundamental concern about this bill. At the heart of the bill lies a blatant disregard for the United Kingdom's obligations under international law. Clause 3 of the bill shows that the legislation seeks to disapply key elements of the Windsor Framework. This is not a matter of abstract legal principles. It strikes at the very core of the UK's credibility as a nation that honours its commitments. The Windsor Framework was the result of years of painstaking negotiation designed to balance Northern Ireland's unique position post-Brexit. For the UK to unilaterally disregard its provisions is not only a breach of trust with our European partners, but a dangerous precedent that could have profound consequences for our future trade agreements and alliances. Madam Deputy Speaker, this is not just a technical breach, it's a move that erodes trust in the UK's ability to uphold our agreements, and international partners are watching closely. If passed, the message this bill sends is clear. How can we expect to secure future trade agreements or maintain our standing on the global stage when members of this House seek to so readily abandon the commitments we've made? Instead, this government has grounded itself in respect for international law. Only by sticking to our word can we rebuild this country's reputation, which was trashed by the previous government's shocking decision to break international law in specific and limited ways. Let's be clear. You either abide by international law or you don't. It's not an à la carte menu where you can pick or choose. This government understands that, and that's why we will be sticking to our agreements. Madam Deputy Speaker, the economic implications of this bill are just as troubling. Under the Windsor framework, the at-risk, not at-risk tests provide a clear and workable solution, allowing for the smooth movement of goods between Great Britain and Northern Ireland, while protecting access to the EU single market. By removing this mechanism and replacing it with undefined alternative models, the bill introduces huge uncertainty. This lack of clarity will create significant operational challenges, leaving businesses without a roadmap for compliance. The small and medium-sized enterprises that drive Northern Ireland's economy are particularly damaged by this, as the bill will disproportionately burden them. Many lack the resources.
Thank my honourable friend for giving way, and she's making a very powerful point about trade. And would she agree with me that the ripple effects from disapplying the Windsor framework would actually hit all of us, including constituencies like mine, where they were looking forward to the government's priority of resetting our relationship with the EU and finding some of those practical solutions, for example, on a veterinary agreement, that we actually have had some degree of consensus, I think, in the House today, would help deal with some of the problems that honourable members opposite have raised.
Thank the honourable member, and he's made a very good point. I'm, of course, focusing on businesses in Northern Ireland, and many of them lack the resources to implement the dual tracking system for goods destined for different jurisdictions, and that will place them at a significant competitive disadvantage. The Windsor framework has provided Northern Ireland with dual market access, and this is a unique and valuable advantage that no other part of the UK enjoys. It's enabled Northern Ireland's economy to remain one of the strongest performing post-Brexit. Businesses have adapted to the framework's provisions, and over 9,000 firms are now registered with the UK Internal Market Scheme. This bill, however, throws all of that progress to the wind. The bill will deter investment and create further trade barriers, undermining Northern Ireland's status as an attractive place to do business. For small and medium-sized enterprises already operating on tight margins, the additional costs and administrative burdens could be devastating. After years of decline under the Tories, these businesses need certainty, stability and support, not a chaotic and fragmented regulatory landscape that leaves them scrambling to comply with conflicting rules. The people and businesses of Northern Ireland deserve better than what this bill proposes. Madam Deputy Speaker, can I look at the critical issue at the heart of this bill in Clause 19? This clause alters the consent mechanism for Articles 5 to 10 of the Windsor Framework, replacing the current system of simple majority voting with a requirement for cross-community support as been laid out by the member opposite. While this change may appear on the surface to be a measure to strengthen democratic buy-in, in reality it risks paralysing decision-making and undermining the delicate political equilibrium established by the Good Friday Agreement. I will allow the member to speak.
Allister. The delicate political balance. The delicate political balance, we are told, was solved by the Belfast Agreement. And it was the Belfast Agreement that decreed for every key decision there should be a cross-community vote. Yet this is a key decision and the cross-community vote is to be abrogated. Where is the respect from the honourable member for what she is saying in terms of the efficacy of the Belfast Agreement or of this vote?
I thank the honourable member for his intervention. And let's look at the intent behind the existing democratic consent mechanism. The Windsor framework carefully designed this process to ensure that the people of Northern Ireland, through their elected representatives in the Assembly, have a say on whether the key provisions of the framework continue to apply. By allowing a simple majority vote, the framework ensured that the democratic will of the Assembly could be expressed efficiently and effectively. This system reflects the realities of a power-sharing arrangement, where decision-making can already be complex and contentious. Clause 19 of the bill, however, proposes a significant and disruptive shift. By requiring cross-community consent in the Northern Ireland Assembly, a majority of both Unionist and Nationalist representatives, the bill introduces a mechanism that grants de facto veto power to either community. And the honourable members opposite do know this. This risks creating scenarios where no decision can be reached at all, with no explanation in the bill for whether the Windsor framework would continue or not under such circumstances. Such provisions invite obstruction and brinkmanship on such a critical issue. I will give way.
Or that, because she's actually countering what she said earlier when she said she had read the Good Friday Agreement. Obviously she hasn't understood it, because that cross-community has been central to the protections that were applied in the Belfast Agreement at the start to ensure protections for minority concerns. That was the purpose of it. What she's actually saying in regards to this change from 5 to 10 with removing cross-community support and consent has undermined the principles of the Belfast Agreement that my party paid so much for.
I thank the honourable member for his intervention, and indeed we disagree on that point, but can I reiterate to him I have read the Good Friday Agreement from cover to cover. Now, the introduction of a cross-community requirement will only place enormous burdens on the Assembly, which has already struggled to function effectively in recent years. Adding another layer of complexity to the Assembly's decision-making process only risks further entrenching this situation, making it even harder to deliver for the people of Northern Ireland. Madam Deputy Speaker, we must also consider the message this provision sends to the people of Northern Ireland. By imposing additional barriers to democratic decision-making, the bill risks fostering a sense of disenfranchisement and disillusionment amongst the electorate. How can we expect the people of Northern Ireland to place their faith in the Windsor framework if institutions are deliberately hamstrung by measures designed to perpetuate stagnation rather than promote cooperation on this vital issue? The Windsor framework was carefully designed to strike a balance between competing interests. This bill, by contrast, undermines that delicate balance, replacing pragmatic solutions with political posturing that I'm afraid serves no one. There is also an absence in the bill of a clearly articulated framework to replace the existing regulatory mechanisms established by the framework. Under the current system, Northern Ireland operates with a dual regulatory sphere, giving it unique access, as I'd said earlier. This arrangement, while complex, has provided a measure of certainty for businesses. They know which rules apply, how to comply with them, and the benefits of adherence. This bill, however, removes critical aspects of the existing framework. This would create a vacuum, leaving businesses and regulators alike with more questions than answers. And the resulting uncertainty, of course, threatens Northern Ireland's prosperity. And that's before I even get on to the fact that there is no clear timeline for the implementation of this bill. It provides no roadmap, no phased implementation plan, and no transitional support for affected parties. The bill, therefore, will only create a chaotic environment in which businesses must prepare for the unknown, potentially leading to disruption, delays and financial losses. For small and medium-sized businesses which lack the resources to navigate complex regulatory shifts, the consequences will be devastating. In conclusion, Madam Deputy Speaker, the regulatory uncertainty created by this bill is not a minor oversight. It's a fundamental flaw that undermines its viability. The bill, far from being a technical adjustment, is a destabilising force. At its core, the bill flagrantly disregards the principles of international law and the commitments the United Kingdom solemnly made under the Windsor Agreement. But perhaps the most frustrating aspect of the bill, Madam Deputy Speaker, is that it represents a colossal missed opportunity. Northern Ireland is uniquely positioned to thrive as a bridge between the UK and the EU, leveraging its dual market access to attract investment and drive growth. The Windsor framework, while not perfect, is a pragmatic solution that provides the stability and predictability necessary for this unique position. Instead of building on that foundation, this bill tries to tear it down, replacing a functioning system with chaos and division. It prioritises short-term calculations over long-term economic and social stability. Northern Ireland deserves better than this. Its people, businesses and institutions deserve a government that legislates responsibly, with foresight and care, rather than rushing forward with reckless and ill-conceived measures. Madam Deputy Speaker, this House has a duty to legislate responsibly, to weigh the long-term consequences of our actions, and to uphold the principles that underpin our democracy and our international commitments. This bill fails on all counts. It is not simply flawed, it is fundamentally unfit for purpose. I urge my colleagues to reject this legislation and demand a more thoughtful, inclusive and workable approach to addressing the challenges facing Northern Ireland. Let us not act out of political expediency, but out of genuine commitment to the people, businesses and institutions that rely on us to get this right. Thank you, Madam Speaker.
Shadow Minister Alex Burghart.
Thank you very much, Madam Deputy Speaker. It's a pleasure to be called in this debate. It's very nice to have an opportunity to stand up. And it's also very nice to see such enthusiasm for this subject on the other side of the House. I can see how very disappointed many honourable members are not getting called in this debate. There are so many things that one might say to this debate. This extremely interesting bill that the honourable gentleman from North Antrim has brought before us, which, as we know, is not going to progress because the party opposite intends to talk it out. But I want to talk about some of the ideas and principles that have been raised today, and indeed some of the ideas and principles that are contained within his interesting draft legislation. Many of the new and enthusiastic members opposite were not here during the difficult days of 2016, 2017, 2018, 2019, 2020. And some senior and experienced members were. And there is a sort of temptation to look into that sort of densely packed history and close it again and move away. Perhaps not to go back quite as far as Sophocles. Though I was reminded, I know the honourable gentleman from Bootle always peppers his interesting remarks with cultural references. I was reminded of something else Sophocles said during this debate, which is that there is a point at which justice does injury. And there is something in these conflicting ideas of law, of international law, of obligation and principle that rings with Sophocles. And, make no mistake, in those Brexit days, there were mistakes made by honourable members on both sides of the House. And indeed, my honourable friend from Chingford has referred to mistakes that were made by the then administration. And they created a starting position which some of us did not want and which has had long consequences. But we are, as has often been said, where we are. And how we have got here is from those starting points to have a progress of a type. The initial proposals around the backstop were unquestionably bettered by the protocol. The Windsor framework, I believe, is better than the protocol. I believe the Windsor framework with safeguarding the Union is better than the Windsor framework. But that does not mean that further progress is not possible. And as the Windsor framework approaches its second birthday, I think it is worth taking stock of what we have seen emerge from it. And obviously, it made some improvements. It managed to achieve some of the things it set out to do. But there is, as been raised by honourable members on this side of the House, still a problem with the flow of certain goods between Great Britain and Northern Ireland. That is not a frivolous concern, it's a serious concern. The promised investment that we were going to see Northern Ireland become a Singapore of the West has not happened, and my conversations with and visits to Northern Ireland, I've asked those questions and heard the fact that certainly hasn't yet materialised. And the other night in the House, we were debating the Secretary of State's recent statement about legacy and about challenges that he is bringing to judgments made in the Court of Appeal in Belfast, where the interpretation of the Windsor Framework is a very live issue and could have very profound and long-reaching consequences for how law operates in this country. Even then, it must be acknowledged that the popular opinion in Northern Ireland around the Windsor Framework itself is shifting slowly. It was Windsor Framework, Queen's Belfast can perform these regular surveys, regular polls of how people feel about it. It's becoming less popular over time. That may change, but there is an issue there. And these are all practical issues before we reach the serious issues which must never be discarded about sovereignty. And so if that is where we are right now with the framework, we have to ask what will happen next. And this Labour government was elected not 6 months ago with a considerable majority and a manifesto that said that it was going to implement the Windsor Framework in good faith and protect the United Kingdom internal market. It must be sure to do both. That both elements of that promise to the British people are extremely significant. And nowhere else, there are many examples raised on this side of the House of issues that have arisen with particular goods and particular sectors. But nowhere else is that more pressing, I think, than the SPS arrangements, veterinary medicine arrangements. I was talking to farmers in Belfast just a few days ago, and they said we're concerned that the government doesn't appreciate how much time is of the essence. I think my honourable friend from Belfast East mentioned the need for haste in the Paymaster General's work. That is indeed pressing, because if the timescales for the government, indeed the timescales for the EU is briefing out, are the next 2 to 3 years, well, the grace period is due to end at the end of 2025. And so we are already in a zone where over 50% of Northern Ireland's veterinary medicines will not be sourceable from the UK. And that has a huge implication for farming and agriculture, which, as I don't need to remind members of the House, is a major part of the economy in Northern Ireland. So it's good that they're happy to give way to the honourable.
Much grateful to the honourable gentleman for giving way. I wonder if I might just clarify. Does the honourable gentleman think that this bill is likely to make it easier or more difficult for the government to enter into negotiations, successful negotiations, on a sanitary and phytosanitary agreement?
I think, as the honourable gentleman who's put down this bill said, if this bill were to pass, as we know it won't because it's being spoken out, then there wouldn't be a need for that sort of deal in the same way, because goods would be flowing freely from GB to Northern Ireland. So the question is at best. I won't actually. The question is at best. The question is at best academic. But I have points I want to make, and I want the Minister to have time to give her speech and to take interventions from all sides of the House. And but I say one of the things that made the Windsor Framework, strengthen the Windsor Framework, was of course safeguarding the Union, which was is an absolutely critical place, critical to where we are now, because honourable members will remember that the Assembly only came back together because of safeguarding the Union. And if one starts to remove elements of safeguarding the Union, then it's possible, we hope it won't be the case, but it's possible that that agreement starts to fall away. And if that agreement starts to fall away, then we risk the stability of our institutions in Northern Ireland. So I say to the Minister today, there are many points that one could raise. I've asked a lot of parliamentary questions about this. But there are some specifics that we really are owed some detail on now. The first is about the independent monitoring panel. We have the internal market system, which is supported by the UK Internal Market Guarantee, and that is overseen by the independent monitoring panel. But when will the independent monitoring panel first report? Second, we have Intertrade UK, a potentially very important body. We were all pleased to see Baroness Foster appointed in September, but as far as I'm aware, the terms of reference for Intertrade UK still haven't been published. This is really not acceptable. We are now 3 months on from appointing a chair, and we're very many months on from the publication of Safeguarding the Union. Intertrade UK must have its terms of reference. They must be shown to members of this House. Similarly, we've got to have regular updates from the government on business preparedness for the internal market system. It's not enough for us to depend upon the proactive asking of questions by members of the opposition. The government should regularly be reporting on this. And finally, I very, very briefly.
So I thank him for giving way. I'm sure he'll be grateful for a rest and a sit down on the bench again. And you have been very, and the member has been very, the honourable gentleman has been very constructive, and I welcome that as well. But the reality is the government has largely inherited this situation, and it is quite a difficult situation. There is friction, and we've heard from that, and there's real issues that we do want to discuss. Do you not feel you've been a little bit impatient? And does the honourable gentleman not feel being a little bit impatient in terms of demanding progress so soon?
Well, I thank the honourable gentleman for that sort of lengthy intervention. But no, I don't think I am, because this is an extremely important subject. And obviously, we were all aware when the command paper was put down earlier this year, then this was going to need to be done. The framework was in the Labour Party's manifesto, so we assume that they were making these preparations. It's perfectly possible to put together, for example, terms of reference for Intertrade UK within 3 months. So no, we're not being impatient. These things need to be done for a reason. They need to be done to reasonable time. So, but I know that the Minister is alive to the importance of these things, but I do hope that she will hurry this work along. So it is clear that under this government the Windsor framework will continue to run. How successfully it runs will depend upon any deals they strike and whether they are able to uphold the commitments that were made in Safeguarding the Union. But as has been raised by honourable members on this side of the House, the limitations of the Windsor framework in practical terms, but also in terms of constitutional principle, are clear. And that's why we must continue to seek for even better solutions. And it was very, both the honourable member for North Antrim and my right honourable friend from Chingford and Wood Green talked about the central issue which is in the bill, which is mutual enforcement. Now, mutual enforcement was, during the Brexit negotiations, categorised as magical thinking. But I think that was unfair, and I think that was a ploy used by people who didn't want to do it. It's thinking which has a magical potential, but it's not magical thinking. My right honourable gentleman from Chingford spelt out why. It's because it's already done. It's because we've seen it work. We've seen it work in the EU's dealings with New Zealand. And we also heard very significantly that this was something that Monsieur Barnier was open to, that people who were involved in the formulation of policy at the time have stated again today that they know is deliverable. And so I just don't want anyone in this House on either side to think that this is an issue that cannot be pursued. I think it can, and I think it must, that if we have the goodwill and we have the technology, there is no reason why there can't be a future with mutual enforcement playing its role. And I remember being told repeatedly during the Brexit negotiations as a backbench member of this House that there couldn't be any border checks, there couldn't be any infrastructure, there couldn't be any checks near the border. And but of course, in recent months, we've seen that isn't true. And we know that this isn't true because the Republic is conducting Operation Sonnet. Operation Sonnet, which they're perfectly entitled to do. Operation Sonnet is a series of checks performed by the Garda on people crossing the border to make sure that people are not crossing illegal. I'll give way very briefly to the Honourable Lady.
I thank the Honourable Member for giving way and I commend him for his speech. Would he agree with me that today, sadly, is a missed opportunity? We had in this place, within our grasp, to end the application of EU law in Northern Ireland, restore Northern Ireland's place within the UK internal market by removing the Irish Sea border and address the democratic deficit, and we failed. So we'll just have more of the same as of tomorrow.
I'm very glad the Honourable Ladies had an opportunity to make that point. And but as I say, we've seen that the Republic are carrying out checks on the other side of the border, and so things that we were told were not possible are. And if that is the case, then it must open up possibilities for the future. So, Madam Deputy Speaker, look, I remain strongly of the view that the Windsor Framework with safeguarding the Union is a better solution than the Windsor Framework was, that the Windsor Framework is a better solution than the Protocol was, that the Protocol was a better option than the backstop. But that does not mean that there are not better solutions available. Those of us who believe in the Union do not wish to see a sea border. Those who wish for a settlement, those of us who believe in the Union do not wish for a settlement that infracts upon the Acts of Union. Mutual enforcement obviously has the potential to be a sensible alternative, particularly if it is backed up by very serious penalties for those who infringe it. Indeed, in those circumstances, it could be remarkably effective. So we wouldn't start from here. We are where we are, but that doesn't mean that we can't get back to where we once belonged.
Minister Fleur Anderson.
Thank you, Madam Deputy Speaker. Let me begin by expressing thanks to all those who have contributed to this debate so far, and I'm sure there'll be many more after me as well, and to the honourable gentleman, the member for North Antrim. He has set out his view before this House today with the same ardour as he did a fortnight ago, although with greater length, that he was allowed in Westminster Hall, and during his time in Stormont previously as well. And I think it's important that I restate to him what my honourable friend, the Northern Ireland Secretary, said to this House a fortnight ago, which is that the government wants Northern Ireland to prosper and flourish, and for it to do so as an important part of the Union. On that matter, I think many of us may find some agreement. We are here for the best for the people of Northern Ireland. I would also reiterate here that the government's commitment to both the Windsor Framework and to the UK internal market is on that point that my right honourable friend, the Northern Ireland Secretary, respectfully disagreed with the honourable gentleman, the member for North Antrim, before this House a fortnight ago. I will be setting out the objection of the government to this bill, which is not compatible with international law, which does not account for Northern Ireland's unique circumstances, and which would in effect take powers away which are given to the Northern Ireland Assembly to make decisions about Northern Ireland. It would result in a regulatory black hole, which would be very bad for businesses, for jobs, for growth, for the Northern Ireland economy and for the rest of the United Kingdom. And I'd like to start by outlining some of the good news for the Northern Ireland economy, which show that the Windsor Framework and the prospect of stability, the executive returning, the stability of a new Labour government, that is giving for the economic outlook in Northern Ireland. The Northern Ireland Composite Economic Index indicates that economic output increased by 0.4% over the quarter to June 2024 and increased by 2.3% over the year. Ulster University's Economic Policy Centre shows that there is a forecasted growth rate of 1.4% in 2024, 1.7% in 2025 for Northern Ireland. The region's economy is performing better than expected at the start of the year. This has been driven by strong growth in employment, particularly in the transport, construction and health sectors. Northern Ireland Statistics and Research Agency's the Inter-Department Business Register shows the number of VAT or PAE registered businesses operating in Northern Ireland in 2021 is estimated to have risen by 1,550 since 2022 to 77,740 and is continuing to increase. I could go on, and I've got a longer list of the good news stories for Northern Ireland. The economy is working, but all the businesses I speak to talk about stability, the need for stability. And that's underlying the premise of this bill is that we would change that stability, we would go into uncertainty and chaos, and that would not be good for the Northern Ireland economy. I give way.
The Minister State for giving way. Minister, honestly and sincerely, each one of us here in this side of the House who have concerns have presented examples where it isn't working, and what went through this European Union withdrawal bill that the Honourable Member for North Antrim put forward was the way to address those issues. I give two examples of businesses, and I have many more that I could give if the Deputy Leader of the House was to let me do so, but I know she won't. But with those examples that I give, really you might say, the Minister might say the things that have been done are positive, but for us, there isn't positivity. Whenever my constituents from businesses tell me they will no longer be able to trade, no longer to have a business, no longer to give employment, no longer to give wages, that has to be addressed. And could I ask the Minister of State, those are the questions we're asking, tell us what's going to happen.
I've listened carefully to the Honourable Member's examples that he's given from his constituents, and they do cause concern. We need to listen to them carefully, and I do absolutely understand the concerns raised by other members in this debate as well, and those reasons why this debate is useful to talk about those areas. But if you don't have the Windsor framework, you don't have a framework from within which to negotiate changes. And there have been many changes as has gone on since the establishment of the Windsor framework, which shows that it's able to flex, to allow negotiation and to put in those practices, those schemes, the internal market scheme, the other schemes which enable smooth flow of trade. And that's the benefit of having the Windsor framework versus ditching the Windsor framework and not having it. I certainly would.
But the flexibility of the Windsor framework in allowing change. Of course, the Windsor framework wasn't able to change one word of the substantial content of the protocol, because the protocol involved giving to the EU control over those vast swathes of our economy that arise from those 300 areas of law. It involved putting Northern Ireland under the EU's customs code. It's only if you retrieve that you can retrieve Northern Ireland into the internal market of the UK and out of the single market of the EU. The Windsor Framework does none of that and isn't capable of doing any of that with the greatest will in the world. It can tinker, it can't change.
I will be coming to the point of the 300 laws that he's referred to, because it is important, and it is important to put that in context. But I do reiterate that having a framework within which to negotiate is going to be better for all those areas that he has mentioned than not having a framework and resetting that and trying to do that what has been done and talked about for the last 8 years in just 3 months, which this bill would provide for. I'd like to begin by covering those points made by the Honourable Gentleman and by others, those sincerely made, on which the government must sincerely disagree today. Before I come to the substance of the bill, it's important that this House is dealing in facts, and I'm afraid that the Honourable Gentleman's speech opening this debate contained a number of factual inaccuracies, which is important to correct. He claimed that a Stormont break is nothing more than a mere request by the Assembly that the law can be disapplied. Some kind of backseat driving was referred to. That is incorrect. In fact, Schedule 6B of the Northern Ireland Act places a strict legal duty on the government to act where the break is validly used by the members of the Northern Ireland Assembly. He has used hyperbolic and frankly incendiary language, impugning the motives of our partners and allies, all the while ignoring that it was this House that voted for the arrangements that now apply, Madam Deputy Speaker. I can only presume that he supports the sovereignty of this Parliament. Indeed, he's opposed the existence of the Northern Ireland Assembly under the Good Friday Agreement, so he should reflect that the Windsor Framework represents the democratic will of this House. He has made repeated reference, and again, to the 300 laws applicable in Northern Ireland. He ignores that, under the Windsor Framework, over 1,700 pages of EU law, with the accompanying ECJ jurisdiction, have been disapplied, covering areas like VAT, medicines, that's been referred to, food safety, so that the UK government can decide and UK courts can interpret. I've got my own views on this whole process, but that was faithfully applied after the democratic vote to leave the withdrawal from the EU. I will give way, but I won't have time to go to all my points if I'll be giving way too much, so I won't be doing it too much.
Are there or are there not 300 areas of law which are now beyond the legislative reach of this House and the Assembly because they lie within the purview of the European Parliament? Is that true or false?
There was this trilemma: keeping the integrity of the UK internal market, avoiding a hard border on the island of Ireland, and respecting the legitimate interests of our EU partners to have a legitimate interest and be able to coordinate that trade. Those 300 regulations allow a very, very small amount of the whole lot, and they allow for things like dairy farmers to move milk over the border and back, which I'm sure he would agree is needed to happen. They allow for smooth movement of trade. They are the remaining regulations, and they enable businesses in Northern Ireland to go about their business. He has claimed that the vast majority of veterinary medicines are at risk of being discontinued at the end of next year. This is also incorrect. He is right that there are issues which the government is working hard with industry and farmers to address. There are ongoing concerns, and I'm glad they've been raised by members today. But he's simply wrong to say that the vast majority of veterinary medicines are at risk, and engagement with industry suggests no such thing. He claimed, Madam Deputy Speaker, that the Windsor Framework has caused shortages in medicines for diabetes. Again, it's incorrect. What is correct that various factors can sometimes give rise to gaps in medicine supplies across the United Kingdom. The overwhelming majority of medicines are in good supply, and we have well-established processes to manage supply issues. His claim that this is in any way as a result of the Windsor Framework or specific to Northern Ireland is wrong. The Honourable Member held up the Good Friday Agreement and asked where that agreement demands there be no border infrastructure on the island of Ireland. I know that the Honourable Member has his own reservations about the arrangements about that agreement, and perhaps this is why the facts have not been understood. That agreement was one of the proudest achievements of the last Labour government, and the peace and security that agreement has produced, premised in no small part on the normalisation of security and the absence of a hard border, is an overwhelmingly good thing. The Honourable Member asked for quotes. I shall oblige him. The agreement itself committed to a normalisation of security arrangements and practices, and committed the British government to the objective of as early a return as possible to normal security arrangements. The Common Travel Area has existed for over a century. It's integral to the movement of people and goods on the island of Ireland. I'm going to make some progress now. To the government's mind, the commitment to normal security arrangements could not be met under the Common Travel Area with a hard border of the sort that the Honourable Member's bill before us today would institute. The Honourable Member for North Antrim has indicated in his remarks that, come what may, he would want his part of the UK enabled to follow the rest out of the EU. I need not remind the Honourable Gentleman that the whole UK left the European Union, and that debate has been settled. So we can see here that the Honourable Member for North Antrim would prefer that hard border, that damaging hard border for Northern Ireland. I will give way.
The Minister for giving way. We should first of all accept that the security arrangements referred to in the Belfast Agreement were security arrangements. Army watchtowers, army posts along the border. And secondly, despite what she said about the Common Travel Area, does she now accept that the guards are actually stopping vehicles on roads in and out of Northern Ireland and searching them and to take people off because they believe they're illegal immigrants? So the Common Travel Area isn't even being respected by the Irish government itself?
There are absolutely minimal stops along the border. It is not a hard border, but that would be a very different circumstance if the Honourable Member's bill was put forward today. The Honourable Member is about insinuating an ideological hard Brexit. No, I will be making some progress now. I would ask the Honourable Member to go to...
I'm very grateful to the Minister, but could I just cautiously and gently urge her to draw back from the comments she's made about the movement around border and the security around border. One of the most incendiary things to occur during the discussions with the European Union and this British government was Leo Varadkar showing a copy of the Irish Times, showing a border post that was blown up by the IRA during the Troubles, and suggesting that trade arrangements could lead to the same thing. He was wrong then, and I think she's in danger of stepping into that territory today.
I hope the Honourable Member understands that what I'm talking about is the difference between a hard border and a soft border, and the difference that the Windsor Framework enables smooth flow of trade to happen, which is good for businesses across both sides of the border and also safeguards the Union. This Windsor Framework strengthens the Union. It does not damage it. It actually strengthens it and ensures that it can continue. I will be making some progress now because time is actually running out in this debate and I do want to get to the end. It is simply, on the consent vote, it's simply wrong to claim that all major decisions in Northern Ireland require cross-community agreement. As the Honourable Member for South Belfast pointed out, cross-community agreement wasn't required for Northern Ireland to leave the EU, and it's not a requirement for constitutional change in line with the principle of consent in the Good Friday Agreement. The reality is that the Good Friday Agreement never envisaged a device like the consent vote, and so the arrangements for that vote were determined by this House and the amendments it made to the Northern Ireland Act. So let me briefly thank the other right honourable and honourable members who have contributed in this debate, in particular the Honourable Member for Bootle, the Honourable Member for East Belfast, and the members for South Down and Mid Down, the member for Chingford and Woodford Green, the member for Ealing, Southall, the member for Brentwood, Ongar, and others yet to contribute in this debate as well. There have been many issues raised which I will be taking away as a minister and which I'm grateful for raising, and I'm also grateful for the amount of comments made about continuing to speak and about dialogue by the member for Brentford and Ongar and others. Turning now to the substance of the bill itself, Mr Speaker, I shall set out three reasons, Madam Deputy Speaker, my apologies, I shall set out three reasons why the Government cannot support it today. Firstly, the bill cannot be said to be compatible with international law. I know that assertions have been made about international law during this debate by the Honourable Member, but it's absolute truth that it's premised on replacing the agreed measures under the Windsor Framework with unilateralism and uncertainty. In the circumstances, that, to my mind, would constitute a breach of the UK's agreements that would be unlawful on the international plane. This is a government committed to the rule of law and the meeting of the UK's international obligations. What is contained within this bill are a set of unilateral measures that do no such thing. It's not an abstract matter. It's a matter of consequence. We must be clear that the flagrant disregard of international law and the respect of our treaty obligations is never in any nation's interests. Doing so would weaken our standing abroad. It would weaken our prospects for beneficial international agreements in the future. And that matters particularly for Northern Ireland. As the House knows, the Government was elected with a mandate to reset our relationship with the EU, to tear down trade barriers, including negotiating a sanitary and phytosanitary agreement. There is significant potential for many of the practical issues which some of the honourable members have raised about the operation of the Windsor Framework to be improved or addressed through the negotiation of such an agreement. That is in the best interests of Northern Ireland, and it's in the interest of the United Kingdom as a whole. But of course, a nation that turns its back on prior commitments cannot hope to persuade others to enter new and beneficial arrangements. As a proud Unionist, I know the honourable gentleman will appreciate the potential benefits of such an agreement to Northern Ireland and to strengthening the Union. So I confess to be somewhat baffled that he will promote legislation that will be so detrimental to the prospects of securing future agreements. Of course, it's playing fast and loose with the rule of law, and that is very bad for business. It would create conditions in which businesses and citizens can never be certain as to which rules will be respected and to which will not. The bill will create uncertainty over what regulatory framework applies in Northern Ireland upon which businesses rely to trade on now, including the ability to trade across the island of Ireland without friction. And it would do so automatically, bringing down a hard guillotine on those trading arrangements in just 3 months, leaving businesses no time to adjust. It would be an economic shock. During my time working on international development campaigns, I saw firsthand at the World Trade Organization what regulatory certainty and uncertainty can do for the prospects of small businesses, for the jobs they create and the economies they contribute to. I can personally attest it's better for those businesses to work on the basis of agreed trade arrangements rather than leaving them stranded in the choppy waters of regulatory uncertainty. Secondly, the bill does nothing to account for Northern Ireland's unique circumstances. Let's be honest in this House, these issues have been discussed, debated, analysed and dissected for nearly a decade now, as other members have mentioned. They've occupied the political life of the nation for some time. And it's right that they've done so. It's right. The concerns of the honourable gentleman, the right honourable and honourable members from the DUP and UUP too, are real, legitimate and deserve to be taken seriously. But while I understand and respect the strength of failing behind this bill, I put it respectfully to the honourable gentleman, the member from Lord Antrim, that neither this bill nor the other similar variations of this proposal advanced over the past 9 years do anything to address the practical issues in a more stable and sustainable manner than the Windsor Framework does. I'm going to make progress. The core challenge remains, as I have said earlier, about this trilemma. How do we preserve the integrity of the UK's internal market, avoid a hard border on the island of Ireland, and respect the legitimate interests of our EU partners in protecting their single market, just as we seek to protect ours? This is the answer that the Windsor Framework provides to a very difficult question. And I would say simply to those people across several elections, the vast majority of honourable and right honourable members elected to this place have been elected on a platform of avoiding a hard border. So for good reason, we need to support the Windsor Framework. And thirdly, this bill would serve to prejudice the democratic decision that the Northern Ireland Assembly is making itself. Last month, my right honourable friend, the Northern Ireland Secretary, initiated the progress for the Northern Ireland Assembly to decide on the continued application of Articles 5 to 10 of the Windsor Framework. That vote is provided for in the Windsor Framework and under domestic law, which was strengthened under the terms of safeguarding the Union. It's now a matter for Northern Ireland's executive representatives to decide on. And I'm pleased that the elected representatives of the people of Northern Ireland are able, as part of the functioning, devolved institutions, to exercise the important democratic scrutiny functions included in the Windsor Framework. This bill would fatally undermine those powers in the Assembly that they have over scrutinising regulations that apply in Northern Ireland. The Government will only support sustainable arrangements for Northern Ireland that work for business, protect the UK's internal market and uphold our international obligations. The Windsor Framework does just that, and the Government is firmly committed to doing it, just as stridently as we are committed to the UK internal market and to Northern Ireland flourishing within a strengthened union. But what is just as important is that we will be honest with the people of Northern Ireland about what is and what is not possible and what the trade-offs with various options are. No more magical thinking. No reopening of the wardrobe into a political Narnia of mythical solutions to the practical issues we must consider around trade. No more simplifications that work as sound bites but don't stand up in reality. At this crucial time, the people of Northern Ireland deserve honesty. And I'm glad, one more time.
Does she not agree, though, that what mutual enforcement in principle is about is using what already exists in terms of the trade? So could she not consider that in the course of building on the Windsor Agreement, she might be able to influence them to get rid of that border between Northern Ireland and the rest of the United Kingdom?
I don't know where in the world mutual enforcement has worked, and I understand in some limited ways it can work, but not in a wholesale way, as outlined by the honourable member. So I'm afraid it's a tradition of unreal answers to real and complex challenges that the Windsor framework remains the only credible solution. If this bill was to be taken forward,
thank the Minister for giving way. Just if she would indulge me, just if we kill off this canard of mutual enforcement, the bill that we're debating today goes much further than just suggesting mutual enforcement. It seeks to remove Northern Ireland from the European Court of Justice and therefore from the single market. So it wouldn't just be about in-market surveillance, it would be about entirely removing our economy, including our agri-foods economy, from the single market. Would you agree with me that's why that this is magical thinking, and the suggestion being proposed is absolutely not on the table?
I thank the honourable member for mentioning one area in which that would be disallowed, but there's a whole list of areas which that we are currently working on, that are working well, systems that are working well, which would be simply disapplied. We go back to 1800, to the Acts of the Union, where there actually were differences between the island of Ireland and the rest of the UK. I could go on further about those, but I will come to an end now. If the bill was taken forward, I believe that, far from strengthening our constitutional settlement, though I'm sure the honourable member for North Antrim would wish it, this bill would weaken the UK's constitutional foundations and its international standing immeasurably. It would not be good for businesses in Northern Ireland. It would not be good for the people of Northern Ireland. And for those reasons, the Government will be voting against the bill today. Thank you.
Rupa HoC.
Thank you, Madam Deputy Speaker. And can I echo my friend from Bootle saying how my heart swells with pride to see you in the chair, because we are all the same vintage, as is the Prime Minister, the class of 2015. So look, another Friday, another sitting Friday of private members' bills. And I have to say to the honourable gentleman, he and I were on the same side last week, as was the Minister. I proudly marched through the lobby with him. And he made a passionate speech that day as well. But I'm afraid today I can't support this bill for multiple reasons. I mean, he's not even listening to me. But anyway, with his customary passion, he delivered his argument today with his dramatic flair. But I do think that this bill is actually quite dangerous. And so that is why, and again, my honourable friend, the Minister, made a brilliant speech from the front. Last week, we were talking about safeguards, weren't we? We were talking about limitations of power. And this week, I think this idea of mutual enforcement, it removes all oversight. Last week was all about oversight. This week, I'm a bit worried about all this. And I do think that by seeking to disapply Section 7A of the Windsor Agreement, which enables EU legislation to enter UK domestic law, it undermines the Good Friday Agreement. As my honourable friend said, one of the proudest achievements of the last Labour government, or any Labour government. It attacks human rights protections. And this agreement only saw the light of day in 2023. It's not even a finished process. And he wants to strangle it at birth. I do feel that, and this was only the latest of the divorce bill between GB and the EU revisiting border arrangements. And we all remember that referendum of 2016 that unleashed, this, I don't know what we call it, opened a Pandora's box, can of worms, stuff that we've never seen in this country before. Now, I was a passionate Remainer. My seat is 72% Remain. There were tears in playgrounds all across Ealing and Acton the day after that referendum. But I'm mature enough to realise that the sky hasn't fallen in. So how do we make Brexit work? And I feel that this Windsor framework is one of these things to mitigate. That's what we should be looking at, mitigating, not ripping up international treaties. As my honourable friend and neighbour said, how is anyone, we are still in the process of, we are still hopeful for trade deals with the rest of the world. If we're ripping up an international agreement now, how is the rest of the world going to take us seriously? It's a fundamental breach of trust. And, last week we were talking about assisted dying. Again, people of my persuasion used to say it would be political suicide to leave the EU. I have accepted that the sky has not fallen in. So for those very reasons, I think this is a sensible next step, this Windsor framework. And we were all here, us 2015ers, we've done probably 20 years of elections in half the time. We had elections every other year, 2015, 2017, 2019. And those Brexit years, do you remember, my honourable friend from Bootle? Those late nights that we had. I remember Stephen Twigg sitting behind me, because John Bercow had lived on site, the same place that we went to all those Diwali receptions in the other day. I remember him saying, it was 1 a.m. or something, and he was saying, come on, John, we don't all live here. Because we would have these late-night sittings, we would have... And, you know, Brexit, to my regret, it divided families, it divided parties. Remember all those things that we've put in a recess of our minds, the Cooper-Bowles Agreement, the Dromey-Spellman Amendment, all those things that we had. And this is sort of giving me weird flashbacks. I'm being teleported back to 2017. This is a bit that we were getting to function. Yes, that word Brexit. I don't think I've even said the word so far. I cannot bring myself to say the word. Chequers approach, DEXU. We had 2 entirely new government departments created.
Order, order. Debate be resumed what day?
11th of July.
11th of July.